Excellent. We will get started. Welcome to the hearing of the Committee's inquiry into the Children Education and Care Services National Law Application Amendment Bill 2025. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we're meeting today, and pay my respects to elders past and present, and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today or watching us online. My name is Abigail Boyd and I'm chair of this committee. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of this hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. So I now welcome our first panel of witnesses. Thank you so much for giving time to give evidence, particularly on such short notice. Could I ask each witness, starting from my left, to please state your name and position title and then swear either the oath or the affirmation.
Thank you. My name's Lisa Gibson. I'm from Good Start Early Learning. I'm currently in a national operations role. My substantive role is state manager. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you.
Hello, I'm Chris Legg. I'm the CEO of KU Children's Services. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
I'm Kate Turner. I'm the CEO of SDN Children's Services, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Hello, I'm Kim Bertino and I'm the CEO of Big Fat Smile. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And would you like to commence, any of you, with a short opening statement?
Yes, we will. And we thank the committee for giving us the opportunity to talk with you today. We're here representing KU Children's Services, SDN Children's Services, Good Start Early Learning and Big Fat Smile. We're appearing together today and we wanted to make a joint statement to the committee. We are still assessing the provisions of this very detailed bill and will provide a formal written submission to the committee next week. We represent the state's largest not-for-profit providers of early childhood education and care, with collectively more than 300 years of operational experience, operating more than 310 services and employing over 6,500 staff, and caring for tens of thousands of children each day. 99.7% of our services are assessed as meeting or exceeding the NQS, and 53% are assessed as exceeding, well above the sector average. As not-for-profit providers, every dollar we receive is reinvested into our services, providing high-quality, safe and inclusive learning environments and programs for children. Over many years, we have invested in our workforce to improve quality and embed a strong child safeguarding culture. None of us are perfect, and with thousands of employees and tens of thousands of children in our care, incidents do happen. We report these promptly, we reflect on what happened, we learn, and we constantly improve our systems. The job of developing and embedding a child-safe workplace culture and building safe, quality learning environments is never-ending, and there's always room to improve. The sector welcomes the focus that the government, state and federal have given this year to improving child safety. There are reforms that were outlined by the Royal Commission over a decade ago that we have long called for that are now beginning to be actioned, including a National Educators Register, a National Working with Children check system and a National Reportable Conduct system. It took a while, but it is very welcome all the same. We have been calling for better funded regulators with a stronger stewardship role to ensure that national quality and safety standards are met across the sector and that workforce and supply is being managed to best achieve that. That remains a work in progress. As a key next step, we welcome the outcome of the August meeting of the Education Ministers agreeing a fast-tracked work program to improve child safety in early childhood. We encourage the New South Wales Government to take a leadership role in that forum and to continue to work proactively with other states in the Commonwealth to enact those reforms at a national and a state level, and to advocate for further agreed actions to raise the bar on quality and safety. Acting nationally is important because we are part of a cooperative national system of early childhood education and care. 70% of funding for early childhood education and care in New South Wales comes from the Commonwealth. Quality regulation is reflected in the National Quality Framework, an internationally acclaimed quality framework that underpins our system, with an objective ensuring all Australia's children can access quality early learning. Many of us advocated for a national quality framework for a long time, and it is important that it continue. The National Quality Framework is reflected as a national law agreed by education ministers and then replicated into state law. State laws also reflect some legacy state commitments, such as the higher ratios of bachelor qualified teachers in New South Wales services. The National Quality Framework and the national law are living documents. They have been reviewed, refined and improved constantly over the last 15 years. The initiatives agreed by the Education Ministers last month, following the Child Safety Review, will improve that further. Proposals to amend the national law typically follow a period of consultation with the sector through a regulatory impact statement process. This is best practice legislative development that ensures unintended consequences of reform options are identified and addressed, and the best option is enacted. Our preferred position remains that New South Wales early childhood education and law continues to be part of the national scheme, and the national law continues to be refined and then reflected in state law. Improvements to the national law should be subject to a proper review process, including consultation with the sector, which will have to implement the changes. Even if the intention of the New South Wales Parliament is to do good by going beyond the national law, the risk is that by deviating from it, the national regulatory scheme is effectively undermined. That is a significant consequence of this legislation, which we would caution the Parliament against. Education ministers have agreed to an expedited process led by Victoria to fast-track the implementation of agreed amendments to the national law. We would strongly encourage the New South Wales Parliament to remain part of that process and maintain consistency with the national law. We would also encourage education ministers to ensure there is adequate consultation and the sector even as part of the expedited legislative process. We recognise there's a sense of urgency to these issues, and we will respond to a proper consultation process promptly. That would be preferable to legislation being developed with no consultation at all, as this package has been. In light of the significant work now underway across jurisdictions to address significant quality and safety concerns across the sector, and New South Wales' ongoing parliamentary inquiry, the rationale for prematurely rushing this bill without consultation is therefore unclear. Engaging more thoroughly with providers and stakeholders, not only in New South Wales but nationally, would undoubtedly produce better outcomes for children, families, and the sector and the regulator itself. We recommend that the committee recommend that the bill be laid on the table for 3 months until the result of the review of the provisions of the national law commissioned by the Education Ministers is complete, and the department undertakes a proper round of consultations with the sector on the detailed provisions of the bill. We think a pause to get it right and maintain as far as possible consistency with the national law would serve the best interests of children in our services and of the educators who care for them. We're still working through the other provisions of the bill, and as I said before, we will provide written comments to the committee next week. but my colleagues here will provide high-level concerns before we proceed to questions. So I'm now going to hand over to my colleague, Ms Turner.
Thanks, Chris. I do want to reiterate to the committee that we are collectively strongly committed to improving the safety and quality of early learning, and we do share the government's concern that reform is needed so that standards are met. Well, having said that, while we support the direction of the reform and the changes that have already been agreed to nationally, we have a number of concerns with the regulatory regime that would be enacted in this bill, as well as diverging from the other jurisdictions and the national law. We have concerns that the bill also leaves significant detail to ministerial regulation-making powers, including regulations that may carry custodial penalties and which would appear to breach fundamental legislative principles. We do note that the New South Wales Legislative Review Committee's raised serious concerns about the bill, and we encourage the committee to act on those concerns. We are concerned to allow the Minister to set guidelines and make things mandatory for authorised officers to implement these guidelines, and remove rights for review places extraordinary powers in the executive. And given our experience with inconsistency between authorised officers in New South Wales, this approach is of some concern to us. The other elements where we have concern, noting that we've had very little time to delve into the detail, are things such as the publishing of information when there are investigations still underway. Because this could have an unintentional consequence of unfairly and prematurely damaging educators and providers while an investigation is still continuing. We have some concerns about the suspension of revoking the quality standard for a service while an investigation is still underway and not finalised. As we do about the removal of review rights, we do recommend that this needs to be carefully considered and limited as far as possible, while also ensuring that there persons who are trying to game the system are not able to use the regulations to stay in the system. We are concerned about the tripling of penalties. We do acknowledge that this has been agreed to nationally, and we do agree that penalties need to be different and to be applied. But we do note in the bill that the penalties don't make clear the differences and the proportionality between administrative breaches, which are important but are not to the degree of serious child harm. So we would recommend to the committee that consideration be given to proportionality about how those penalties would be applied in New South Wales. That sense of proportionality at the moment isn't reflected in the bill, and we'd hope that the national legislative package will articulate those, and we encourage New South Wales to wait until that work is done. We can understand what the government's trying to achieve. A proper regulatory impact assessment process would assist to come up with alternative approaches to best achieve that outcome while minimising any unintended consequences, including the consequences of an unclear definition of inappropriate conduct. We would recommend that the New South Wales Government needs to clearly define inappropriate conduct so that the penalties stated in the bill can be applied and is clear to providers and educators and families alike where they will be held accountable and penalised. We'd urge the government to pause and reflect on the best way of achieving tougher penalties and a compliance framework that supports the best outcome for children. And I'll now pass to Ms Gibson.
Thank you. And our CEO, Dr Ross Baxter, sends her apologies. She's currently on leave with her family. We support the objective of making the safety, rights and best interest of children the paramount consideration under the national law. Done properly, this will clarify decision-making for both providers and our teams in services. The education ministers have agreed to make much-needed change. The issues are complex and there's a need for immediate action, and we stand ready to engage with that process. This important reform needs to be carefully thought through. For example, how will it impact on employers' responsibilities under the Fair Work Act? The Commonwealth must be part of that legislative response, and this is why we urge considered approach by New South Wales. By going early, New South Wales risks putting providers here trying to make the new state provision, finding themselves in breach of their obligations under the Fair Work Act. To avoid this and potentially other unintended consequences, we recommend reforms on both sets of laws to be considered together. We strongly support increasing protections for whistleblower and embedding child-safe recruitment practices and mandatory child-safe training. Our note of caution is simply that building workforce capability takes time and comes with significant costs. Training is important, it's also costly, and centre-based services do not have the option of increasing fees to fund it because of the fee cap under the Federal Worker Retention Payment. This is why a national approach is needed. As we understand it, the bill may impose our workforce to processes, heavy fines and public disclosures that do not apply to employees in similar state school settings. The regulatory risks that this creates could make it harder to attract and retain staff as they come to understand the extraordinary powers the bill appears to grant to regulation and authorised officers. We're particularly worried about the proposed fines for nominated supervisors. My colleague, Ms Turner, has already noted that the increased fine regime, which targets individual educators, needs to be carefully considered. I'm concerned our ability to attract and retain staff could become a lot harder if they face a prospect of $34,000 fines for breaching offences as vaguely worded as inappropriate conduct. The onerous responsibility this bill places on nominated supervisors also needs to be unpacked. For an extra $20,000 or $30,000 a year for taking a leadership role in a service, many good educators might become reluctant to do so given the risk of heavy fines for absolute offences that this bill creates. The impact of narrowing review rights and the substantial powers being given to authorised officers and regulatory bodies on educators' work needs to be carefully considered. There are often considerable subjectivity and inconsistencies between regulatory authorised officers on what they will and won't treat as a breach within our services. The legal liabilities will be far more onerous than that faced by educators in our school settings, and we risk losing more good people from early childhood education to schools or elsewhere. For this reason, we urge consultation with the sector and with our workforce on the details of the bill. The national process to clarify what constitutes unacceptable conduct should also be allowed to run its course, to create a workable definition that educators can understand and work within. We have waited a very long time for these vital reforms. We urge the committee to advise the government and its advisors to take a little more time to get them right, in the interests of children, our families, and the vast majority of educators and early childhood teachers within our settings, who come each and every day committed to improving the lives of children and the trajectory of their learning. We would appreciate the opportunity towards the end if my colleague Kim Bettina could summarise our thoughts. We thank the committee for this opportunity and this important work, and we welcome your questions.
Thank you so much, and I do appreciate it wasn't necessarily a short opening statement, but given that we didn't have a submission from you yet because of the time constraints, it's actually been incredibly useful to hear you set out all of the issues in one go. So thank you very, very much. You've covered a lot of the questions I was going to ask. Can I just ask, I know that the Minister has access to the Early Childhood Education Advisory Group, the ECAG. At least 3 of your organisations are on that advisory group. Is that right? All 4? Or
Not all 4.
no. So yeah. So everybody except for SDA.
Correct.
Yeah. Were you consulted on the bill as part of that ECAG process?
Are you happy for me to answer? There was it didn't actually come to the main ECAG, or if it did, I wasn't there and it certainly wasn't in the minutes. There was a special meeting convened to have a look at it. However, I was unable to attend.
Okay. Do you know when that was held?
Can I take that on notice? And
Yeah,
I can
sure.
give you the
I'm
date?
just wondering whether there was any sort of backwards and forwards with the sector at all, or if there was. We
No.
don't know. That's right.
So I feel like, do you know if it was prior to the bill being introduced into the Parliament? And I'm happy if you need to take that on notice.
Can we just take it on notice?
Yeah, sure.
Just so that we're accurate.
Thank you. obviously the extent of the changes, it's a 55-page bill, but I mean, I've taken quite a while to review it as well, because I think you have that there, and then you have to also have the national law, the regulations and everything else on a different screen, and you're sort of trying to piece it together. What sort of time frame would you imagine if this did just get passed? How long would it take to implement, do you think, and what would be do you have any kind of ballpark idea of the extent of resources required to implement it within the sector?
I think that, as we've said, we need to unpack the bill a little bit more in detail to actually understand and operationalise the requirements that we would need to undertake. I think that we have some concerns about perhaps the unintended consequences of elements of the bill, particularly around, as we've discussed, around workforce. And the impact that the penalties would have on our ability to recruit and retain people in key leadership roles. We experienced some of that during COVID, when there was a lot of pressure on services to stay open, to be able to manage the nuances of the pandemic. And we saw people like our nominated supervisors step away from those leadership roles. So we are somewhat concerned about the impact of the proportionality of the penalties linked to the roles and responsibilities.
You spoke in your opening statement about that sort of undermining of the national scheme. I guess the counter to that is that, New South Wales has always had some differences in the way that it's applied the national law, particularly the one that I'd hate to see us get rid of is the ratios. They're having a higher ratio here. What would you say, to a response from the government that it's all going too slow, this is urgent, and New South Wales can't wait, we need to lead by sort of pushing ahead and making these reforms ourselves? I guess what's your sort of counter-argument to that?
I'm happy to just respond in terms of, because we note that the government's already committed another $55 million to boost the regulatory authority, the frontline staff, and what we believe is that's going to give a renewed focus on compliance visits. So the additional compliance visit data is already starting to appear on the SEQA website, and the National Educator Register commences in February next year. So they're elements that we believe are actually going to have an impact, a positive impact on child safety and wellbeing in early education and care services. So given that there's already momentum underway to improve child safety, we're thinking a 3-month pause to the bill would reflect a consistent national law, and I guess proper consultation around the bill, so that we as a sector, we've been operating for, KU's 130 years old, SDN's 120. So I think from a sector perspective, we're well placed to work with government to be able to identify the best possible legislation that can protect children, because ultimately that's what we're here for, and to make sure that children have the best experience that they can when they're in an early childhood education and care service, and the best teaching and learning that they can have to set them up for their transition to school.
And I guess in this area, the problems are so many, like the different things that we've been finding in our inquiry, where there's sort of all of these different factors that are leading to the issues we're seeing, and that sort of complex interaction between things means that there is a capacity for unintended consequences to occur. One of the ones that's been put to me is that if you, for example, if you were living close to a border and you were trying to recruit staff, particularly nominated supervisors, in New South Wales, if these extra fines or the additional fines on supervisors and educators was to be put in place, that might lead to a bit of a talent drain to other states. Is that something that you think as well?
We would agree with that. I think the biggest risk, though, is losing early childhood staff in the early childhood sector to the school sector, particularly with 100 preschools that the department are in middle of developing. I think that we're not unopposed to fines and penalties, but I do think they need to be thought through, and we would still like to see a nationally consistent approach, particularly for providers who actually operate across different jurisdictions.
And that's our current experience. We have centres on the border of Albury, Wodonga. We have centres up in Tweed Heads, and there was a time our Tweed Head Centre used to be under our Queensland state, but given the difference in regulations and the law and essentially the way authorised officers enact that within our state, it was important that we brought that centre, Tweed Heads, into our state. So we do currently have that where educators potentially could go between Albury and Wodonga, but totally different jurisdictions. And essentially, we're not suggesting we don't want this. We're just suggesting that we would like a national consistent approach to be able to support organisations like us that are national providers.
I'll just ask one more and then I'll hand over to Mrs. Mitchell. The other thing that's been put to me is that a lot of the powers that are kind of being made explicit or being bumped up in this bill already exist in some forms, particularly when it comes to, and I know that the a CEQA review pointed this out, that there are conditions that can be placed on services by regulators and are commonly done. We've seen that, I did a little search this morning on the CEQA database. There's plenty of centres that have conditions attached to them, and that condition power can be used to do things like order people to publish information or to, all sorts of things. Do you think that that sort of reticence within the regulator to actually use the powers it has would be solved with some of this bill? How do you see that sort of playing out?
Look, I think the idea of fines make it really black and white. But I think if we use the analogy of driving fines, there's a particular fine for a particular offence. And at the moment we're not seeing that detail because there's very big difference. There's a breach of the regs if you don't have something up on your notice board. Now that's an administrative breach, but it's still a breach. But then on the other hand, at the other end of the continuum, we have children being seriously harmed. So I think what we're saying is we're not opposed to the penalties, we're not opposed to the regulator getting more resources and having more people, but we'd just like to see those details so it's very clear to staff, what the penalties are for the particular breach.
May I come in there too? With having breaches so broad and at the moment applied inconsistently and not clear, there's a risk already that nominated supervisors and staff can throw up their hands and go, I don't understand, so I've had a visit now and this wasn't wrong and now I've had someone else and now it is. The risk is that people go, it is just too hard and it feels a little bit like a lottery of what authorised officer might consider a breach and what isn't considered a breach. And so coming from that experience on the ground, when the sector looks at these penalties, we are all applying that experience and are making assumptions that if that's how these are going to be applied, then that is seriously problematic. Because it is really unclear, not specified the language, for example, of inappropriate conduct. We can make assumptions that we can picture what inappropriate conduct is and impacts children, and we would have no argument there. But we know at the moment our current experience is that can be applied for relatively minor incidents that need to be dealt with different kinds of sanctions and that are really clear for educators so they know what not to do and what to do and when they will be sanctioned. So from current experience, applying to this legislation brings that concern given the significance and size of the penalties.
And just to be essentially a bit more explicit, we have a really good working relationship with the regulator, but as my colleagues have suggested, it does become inconsistent, and I would urge that we ensure that there's resources and support to our authorised officers and our regulatory authority to ensure that there's consistency across enacting the regulations and the law, because essentially, just to be even more explicit, that is not our experience at the moment. So we would urge you to ensure that there's additional support to ensure that consistency for our services.
Thank you. Ms.
Thanks,
Mitchell.
thanks, Chair. Thank you all for appearing and for the incredible work that you do. Very, very highly regarded in the sector and in the community. Some of my questions have been answered, but I just want to go back a little bit to the consultation, and I appreciate you've taken it on notice. There is some parts of this bill that come from recommendations in the review that Chris Wheeler did. Others go beyond that.
Yeah.
And I appreciate you talked about sort of a lack of consultation on the bill. In terms of the Wheeler review, was ECAG briefed on that? Was there advice given to you about those recommendations? Did that happen over the course of the last couple of months?
Yes, it was.
Yeah, okay.
Yeah, and we all received copies of it as
Yep.
well. Yeah.
Okay. And was there an indication from government that that would form the basis of any legislative change, or was it not that explicit?
We assumed that it would.
Okay.
Yeah.
Thank you. The issues around the funding for the regulator, in the bill there is a provision for a new regulatory authority fund, which says that effectively that money from sort of fees and monetary penalties would go into the fund. I just wondered if you had a view on that and whether you think that would be a positive step or maybe one that could have some unintended consequences.
I would worry that if there were not enough penalties coming in, that the actual unit wouldn't be able to operate. So I would not like to see that dependent totally on the penalties coming in.
Okay. And if anyone else wants to respond, feel free. I don't know. Do you want to tell
I think that what Ms. Legg has said, I'm supportive of that too. It feels that it's a bit compromising to link the penalty back to the regulator who's actually applying the penalties. So I guess that's a bit of a legal question that needs to be considered.
One of the other submissions we got from Ciela, who weren't able to appear today, but was along the lines of if that fund was going to be introduced, whether that money should actually be better spent back into reinvesting in the sector education pieces, letting people understand more clearly what their requirements were and supporting staff. Do you think that would be a better approach with that fund as opposed to using it to fund the regulator's operational costs?
Absolutely, I think
I
that...
would agree with, absolutely agree with that.
Yeah.
With anything that is a potential conflict of interest, it's as much about perception as reality. And with a new regulatory authority, that it will need to have the trust of the sector, that they will be acting fairly, and that will be about perception. And so I would strongly agree that the fund would be better invested. The sector needs that investment, and we want to have a posture of continuous improvement, not a set and forget. And I think that would send a really important message.
Yeah, and if I could just add that, since COVID, the early childhood sector's been buffeted. I mean, we're used to change, but this is a major change, and I do think professional development funding needs to be made available. We still have, and we want, new young people entering the sector, so we can't assume that everybody's working at a particular level. So I think that funding of professional development is really important.
Sorry, no, you go, please.
Sorry. Can I also, having worked in the sector for some time, we have seen a difference with our department, our regulatory authority. Essentially, they are far more collaborative now than they were earlier on in my career. And essentially, what we don't want this to do is move away from them being collaborative. Essentially, do you essentially know what I'm trying to say? So, it's very, these fines seem really extreme. So essentially, we don't want to essentially lose that collaborative relationship and that supportive relationship with our authorised officers and our department.
I'll let someone else.
Thank you. I've got Mr. Diadam online.
Thank you, and thank you for your attendance today. I suppose I wanted to go to the sort of threshold question. You would accept that the sector has failed to protect child safety. There's been such appalling instances that have gotten widespread attention in the media. And so obviously there's a sense of urgency in terms of the need to act to assure child safety and also to, I suppose, restore confidence in the sector. I wanted to ask you whether you accept that there is a sense of urgency, and obviously the government is trying to move quickly in order to restore confidence in the sector. So perhaps if you could offer some comment about the question of urgency.
I'm happy to answer that. Look, we would agree there is a sense of urgency, and the cases that have come to light are appalling. But I'd also have to say there are many good services out there offering really high quality and keeping children safe. At the moment, the whole sector is totally deflated. Their professionalism is at question because of a number of operators and staff who are doing the wrong thing by children. So we would totally agree that there is a sense of urgency. We would just like to work with the government through these details to make sure that the legislation that goes through will serve what we want it to do, but also, stand the test of time and not turn more staff away from early childhood education and care who have devoted their lives to their care, protection, and offering high quality early education to children. And we are at that crossroad at the moment. We know that families have lost faith, however, not in all organisations, just in some.
Can I ask about the Wheeler Review? Perhaps you might be able to identify areas of the Wheeler Review that you have issues with or that you disagree with. Are there any recommendations from Wheeler's Review that you would object to?
Can we just take that on notice and maybe put it in our submission? I don't have it with me at the moment. We welcome the Wheeler report. There are many good things in there, but there would be some things that we'd say take some caution with it.
You've spoken. Oh, sorry. Did you want to?
I would just add to that one of the things that we made comment on was about fully funding the regulation to apply the National Quality Framework as it was intended when it was rolled out in 2012. What we see in New South Wales is there's been an expansion of services, so pressure on the regulator to be able to regulate those services, be able to undertake assessment and ratings across the full 7 quality areas. That was what was intended when the National Quality Framework was introduced. What we're seeing now is that some services are having partial assessments, perhaps only 2 quality areas. So for us, one of the key recommendations that we would like to see is the boost in funding to allow the regulator to go back to being able to regulate services as previously done.
Can I ask, you've raised issues about the quantum of the fines and its possible impact. I suppose I wanted to put to you the notion that obviously we want child safety to be paramount, and that's the core and fundamental duty of everyone in the sector. And surely the increase in the fines is a way of communicating in that and making that front of centre for everyone in the sector, from the front line to the management. Don't you think that that's a reasonable proposition? If we're going to communicate a message, clearly some in the sector haven't been placing child safety at the forefront of their operations, and we've found ourselves in the situation that we're in. If we're going to prioritise child safety, don't we need to communicate that? And aren't fines a good way of saying this is very serious, to take this absolutely serious, this needs to be our number one priority? We
would totally agree, but I think what we're asking for is more definition and detail in those penalties and what they're for, because there's a huge sliding scale of keeping children safe. Yeah.
And also, we absolutely support keeping children safe, and I think all our organisations support keeping children safe. And as I said in my opening statement, we just need to be mindful that we're not breaching the Fair Work Act. We have had some instances within our organisation where we've made decisions in the best interest of children, and we've found ourselves before the Commission. So essentially what I suggest we do is ensure that both the Fair Work Act and this bill works hand in hand, because essentially what we don't want to do is implement the bill and be in breach of the Fair Work Act because we haven't applied procedural fairness, or we've applied procedural fairness and then we're in breach of this bill.
Can I take you to, I think you've raised some issue around the ambiguity around inappropriate conduct. I mean, I've looked at the definition. It's clearly premised on the notion of what a reasonable person would do in the circumstances. It's a pretty well understood standard. If you think it's not quite right, then clearly you're at risk of breaching the law. Can you give us some examples of where you think that there'd be some ambiguity around the interpretation of the provision as it currently stands?
I think, again, it's going to be up to the person how they interpret what's reasonable. What I think is reasonable, somebody else may not think is reasonable. So all we're asking for is really clear definitions. If I can give an example, in our child safety policies that we have within KU, we make it very clear. This is appropriate behaviour, this is totally inappropriate. So it makes it very clear for people what they can't do. And I think, we're not asking the bill to go into that much detail, but I do think there has to be really clear definitions of it, because as we've said, there is inconsistency from the authorised officers, and that's because they're human. And there will be differences between staff, what they think is reasonable and what they think is unreasonable.
Can you? I might press you on that. You're obviously experienced operators. So, is there a specific example that you might be able to cite where a worker has done something that they think is reasonable, and that the management and the regulator may interpret as unreasonable?
I can give you an example. People who work in early childhood really generally care about children, and they work very closely together. And it's really, it takes a long time to build a culture where staff are trusted, but also to really have that culture that children do come first. So if I can give you some small examples that have happened in our organisation, an interaction with a child that, say for instance, a staff member raised their voice and shouted at a child. Now, I think that's totally inappropriate. When we talked to the staff, they said, she was just having a bad day. So, from their perspective, she was just having a bad day, and that, that's understandable. It's not understandable from our point of view in keeping children safe. So that's the sort of thing we're talking about, just to make it very clear for everybody what is appropriate and what is not appropriate.
I might hand over to Ms. Mahalik if she's got some questions.
Just thank you. Thank you, Madam Chair.
Through the chair.
Yes,
go ahead, Ms. Mahalik.
Just very quickly, I know that, and look, we thank you for being here, and I appreciate some of you may be concerned about the timing in terms of the bill. Look, I think there is a lot of urgency, and I think all of you would accept that. I also ask, each of you are chief executive officers. You must have some legal assistance in your office. Do each of you rely on lawyers, or do you have legal people within your organisations that could perhaps have a quick look at the legislation your members pay for you guys to have that sort of skills in your office. What I'm putting to you is, I think laying it on the table, I think, is pretty unreasonable for 3 months. I think there is a sense of urgency. I think you've got to think from the point of view of your parents as well. And what we don't want is parents walking away from some of your centres, which I think would be the worst outcome for your staff and your management. And so I just put to you, it's not really so much a question, but rather if there's anything that you do have that you'd like to suggest. And I think one of you said you're still putting a submission in. Who was that? Sorry.
We're putting in
a combined. Is that all 4 or 3?
Yeah.
All four.
All 4. Right. Well, then that's a great opportunity if you can be very specific, because I think Parliament in October would like to get on with this. Certainly, from my point of view, I'd like to get on with it. So, and I imagine the government would too. Can I just ask as well, very quickly, if I'm just surprised about the fund issue. Does that really concern you about the fund? I think otherwise, if it doesn't come back to the regulatory arm, I think that the treasurer would be delighted to take it for something else, right? So, does that really concern you? I mean,
Look, I think it's
Yeah.
reasonable that the income does go back, but
Yeah.
we wouldn't want it to see. I would not like to see the implementation of the regulations being a revenue raiser. for
yeah.
the
Well, I don't
department.
think it's written that way in the bill either.
No.
I just think it's saying that if there's anything, it be redirected back to the regulatory arm.
Could I?
Can I also ask, have you had any
Sorry.
discussions with the unions
Do you want
as
to allow
well? Oh, sorry.
just allow Ms. Bertino to respond?
I was just going to say that it's potentially an opportunity if the funds are used to, in a proactive way, to help build capacity and capability across the sector. We know that at times pre-service training isn't at the level that we would like it to be. We do know that when we employ teachers and educators, at times they're not job ready. So being able to access professional development funding to be able to continue to build that capacity and capability would be a fantastic outcome for the sector, because we know when we've got really strong teachers and educators who know what good practice, who are looking at quality teaching and learning environments, part of that means that you see generally less compliance and breaches. And so quality means also safe and educative environments for children.
Can I just also ask, did any of you, obviously you've talked amongst yourselves in the lead up, did any of you talk to any of the unions prior to coming today?
No, not
No
at
one's
this
had any
point.
discussion? So it's just amongst yourselves at this point.
Correct.
All right. So you will be doing a combined submission. You said next week.
Yes, we will.
Yes.
We are unfortunately out of time. I think I could go on for hours with you. But you did flag at the beginning that Ms. Bettino might want to say something before you go.
Well,
I will be very quick, given that we have run out of
Can I
time.
suggest that we not, Madam Chair? I think. Can I suggest?
Could I ask
9:47?
instead that you table
Yeah,
that, and
just
then it
table
will
it,
still be
yeah.
included in the transcript? Is that okay?
Sorry, we're
Apologies
just
for
very
that.
time poor today.
Thank you. Thanks very much. We really
Thank you.
appreciate you being here. There is a short time frame for returning of questions taken on notice and supplementary questions, but the committee secretariat will be in touch. Thank you very much for your time.
Thank you. We appreciate your
Thank
you.
opportunity. And thanks for your work you're doing.
Okay, so for our next witnesses, I believe we have 2 people joining us on video conference and 1 person here. Can I just check? Oh, there's Ms. Deeth. Very good. Can I just check, firstly, that Ms. Deeth, you can hear us? We can't hear you. You will need to just click off the mute. No worries. While we're waiting, Ms. Page, can you hear us?
Yeah.
Excellent, thank you.
Good morning. I can hear you. Can you hear me?
Yes, we can. That's excellent. Thank you. I'll just check again with Ms. Deeth. Looks like you're off mute now. maybe try. All right, what we might do just while we're getting Ms. Deef's tech sorted is we might just start with swearing in our other witnesses. So thank you very much to all of you for making time again at short notice. We really do appreciate it. I will start here with you, Mr. Lim, if you could state your name and position title and then swear either the oath or the affirmation.
Sure, my name is Chang Lim. I'm from the Australian Childcare Alliance, New South Wales. I'll be taking the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much, Mr. Lim. And Ms. Page?
Yes, hello. I'm just trying to find the oath. Was that attached?
Do you want me to read it out to you? Are you?
Oh, look, if you. I'm sorry to put you
That's
in that
okay.
position, but I just can't. It doesn't seem to be attached to the email.
That's
so I
all right.
probably-
Will it be the oath or the affirmation?
The affirmation.
The affirmation. Okay, if you could just state your name and position title, and then I'll walk you through that.
Samantha Page, CEO, Early Childhood Australia.
Fabulous. So if you repeat after me, I solemnly, sincerely, and truly declare and affirm.
I solemnly and sincerely declare and affirm.
Sorry, try that again. I solemnly, sincerely, and truly declare and affirm
Solemnly, sincerely, and truly declare and affirm
that the evidence now about to be given by me
that the evidence now and about to be given by me
shall be the truth, the whole truth, and nothing but the truth.
shall be the truth, the whole truth, and nothing but the truth.
Fabulous. Thank you. Now, Ms. Deef, how are we doing?
Can you hear me?
Yes, we can. If you could please state your name and position title, and then swear either the oath or the affirmation.
Elizabeth Deef, I'm the CEO of the Early Learning and Care Council of Australia, and I might need you to read out as well, please.
Do you want the oath or the affirmation?
Whichever is the best.
Do you want the one with God or without?
Without.
Okay. So I solemnly, sincerely, and truly declare and affirm
I solemnly, sincerely, and truly declare and affirm
that the evidence now about to be given by me
that the evidence now about to be given by me
shall be the truth, the whole truth, and nothing but the truth.
shall be the truth, the whole truth, and nothing but the truth.
Excellent, thank you. Now I'll start with Mr. Lim. Did you want to be making a short opening statement?
Yes, Chair, but my father will castigate me if I don't allow the ladies to go first.
Fair enough. I will start with you then, Ms. Page. Would you like to make a short opening statement?
Yes, thank you very much. And good morning, and thank you to the Chair, Deputy Chair and committee members. We're very pleased to have the opportunity to speak to you today on behalf of Early Childhood Australia on the proposed amendments to the Children, Education and Care Services National Law Application Act. Just very quickly on Early Childhood Australia, we are a not-for-profit national peak body representing the interests of young children from birth to the age of 8, and have always advocated for high quality early childhood education and care. Our membership extends across the country, but the largest proportion of our members are in New South Wales, and we have a very active New South Wales committee and regional networks right across the state. So we are really pleased to be able to speak to the committee today. We commend the priorities on strengthening children's safety, safeguarding and quality, and recognise that they are interconnected. We commend Australian governments, including the New South Wales Government, for their shared commitment to addressing shortcomings in current and regulatory arrangements. The inquiry in New South Wales has identified a volume and a seriousness of failings within parts of the early childhood sector, including systemic failures that have allowed unacceptable risks of harm to occur, and the devastating stories of child harm, maltreatment and in particular sexual abuse have been difficult for early childhood educators to reconcile with their professional values and ethics. We completely feel very deeply for the children and families affected and understand that the hurt and the terrible breach of trust is enduring. These sort of incidents just should not occur, and we, on behalf of the profession, want to ensure that all children are safe in every setting where they might attend, that services are demonstrating respect for children's rights and best interests throughout their operational activities, and that every setting is providing high quality early childhood experiences in which children can thrive and families can have confidence. Given the very short turnaround of this inquiry and the amendment bill, we have not been able to comprehensively assess and respond to the detail of every proposed change to the legislation, and we haven't been able to consult with our members who are involved and working in early childhood services. Therefore, our commentary is very high level and on particular changes and the overall intent of the legislation rather than the details. And we would join with others who've spoken to the committee about it. We would like more time to consult. We would encourage further consultation with the sector. The early childhood sector, as you know, is very large, over 6,000 services across New South Wales, over 80,000 educators and teachers employed in working directly with children, over 500,000 children attending services. So it is really important that we move with haste, but also in a fully informed way in which people have been appropriately consulted. Some of the systemic issues that we do think warrant changes to the legislation include addressing the mix of providers that are currently involved in the sector, and some of the issues that undermine quality, including churn. So where service ownership is constantly changing over, that compromises quality. It makes it difficult for regulators to do their job. The other issue that's impacting on quality, as we recognise, is oversupply. The viability of services in the oversupply market is problematic, and services are competing for a limited workforce and a limited number of children and families. That results in low occupancy and poor quality across multiple services. And we also recognise challenges, particularly in regional, rural and remote communities, but also in high-cost housing markets where there are chronic workforce shortages. And yes, we do have strategies to address that and a national workforce strategy, but we don't believe it's ever been fully resourced in order to address the workforce challenges. We and others have called for the role of a systems steward, such as an early childhood commission, to provide oversight on issues of supply and demand and systemic issues that impact on quality, such as the location of services and the investment in quality infrastructure and a quality workforce. We also think as we move from what has been a free market approach to early childhood, anyone can build a childcare centre, and as long as they get approved and operate within a compliance regime, they can run early childhood services. We would not accept that in most other areas of professional activity, and we don't think that that is the way to deliver early childhood services in the future. As we move from a free market to a universal system, we think stewardship is particularly important, but so too is a renegotiation about who is providing early childhood services. And we particularly point to the work of Professor Paul Lesserman on creating a social market in which government has much stronger controls over who is operating in the system, and those that are operating in the system need to ascribe to socially agreed goals, objectives and values. We have done a little bit of work on this, and we've included in our submission in terms of some of the things that might be required of a provider to demonstrate that the interests of children are given paramount consideration at every layer of decision making, and I'm happy to talk to that if the committee is interested. In terms of the specifics of the amendments included in the bill, we support the overall intent, and we think it's important to rebuild public confidence in the early childhood sector and to have a strong and appropriately resourced regulatory regime. We are somewhat concerned about whether the penalties will discourage people from reporting or identifying concerns. However, we also think penalties should be substantial. So we just flag that as an issue that might warrant some further consultation. But overall, we support the intent of the bill, and we're happy to speak to any of the detail. Thank you.
Fabulous, thank you. I think we're having trouble with Ms. Deeth's technology again, so I will go to you, Mr. Lim.
Thank you for recognising the critical importance of early childhood education and care in New South Wales, and for inviting me today on behalf of ACA New South Wales. My name is Chang Lim. Members of the ACA New South Wales operate over 1,600 small to medium-sized, predominantly private, family-owned long day care and out-of-school hours care services. In principle, we support the bill, but as our submission, which I had some difficulty submitting last night, we are seeking more information from the New South Wales government, not only about the bill's proposed amendments to the national law for New South Wales, but also in the context of envisaged further changes that will rebuild confidence among parents and families, and also, particularly, early childhood education and care services, educators and teachers. We mustn't continue to put children at the epicenter of everything our members do in their offerings. As such, it gives us no satisfaction to see our sector at this current state. It is completely indefensible that some have been hurt, harmed, and 2 innocent lives lost in New South Wales in the last 14 years. Any one child at risk, harmed, or worse is one child far too many. So I thank this committee most sincerely for scrutinizing the early childhood education and care for children under the current national law, national regulations, and national quality standards as they apply in New South Wales. Let me be clear that the ACA New South Wales does not support the wholesale replacement of the national quality framework in New South Wales. In an important sector that's intrinsically reliant on skilled human beings across all governance settings, we must still recognize that every human being can still be fallible. Failures can and do occur across both private and not-for-profit services. That is why an effective and supportive system is essential. As hundreds of thousands of parents entrust us each day to educate and care for their children from birth to preschool, those children under our responsibility can bear the most negative impact from adult human failings. Nevertheless, we must remain intolerant of anyone and any entity that callously puts profits or surpluses above or worse at the expense of the best interests of every child. And so this bill, the deliberations of this committee and the other parliamentary inquiry of this committee, as well as public discourse, rightly brings us all, including legislators and regulators, to the proverbial crossroads. Without bias, we must critically reflect in order to inform our future. Why has New South Wales achieved 92.6% of services as meeting or exceeding the national quality standards, and yet have the worst results in school readiness since 2009, according to the Australian Early Development Census? And if more than 9 out of 10 New South Wales services have quality ratings of meeting, exceeding, or excellent, then why New South Wales had record numbers of confirmed non-compliances, so high that New South Wales eclipses the rest of the country combined for the last 5 years? And are we more focused on compliance actions, penalties, and punitive actions after the fact, assuming they will be preventative, or shouldn't we instead anticipate risks and ensure that they never become a reality in the first place? The former New South Wales Deputy Ombudsman himself highlighted this week that there are more than 1,000 pages of law, regulations, and guidelines for services, educators, and teachers just to do their jobs. So perhaps the legal and regulatory calibrations, as well as the sectors and the New South Wales government's approach, must be adjusted such that they are children's outcomes focused and supported by streamlined, transparent, clear, unambiguous, measurable, and effective legal, regulatory, quality framework that overtly produce the long-term benefits of early childhood education and care. Perhaps then all New South Wales citizens will be proud of New South Wales government's brighter beginnings that projected dividends of $13 for every $1 invested in early childhood education and care. And to paraphrase someone, to us as adults, children, especially those from birth to 6 years old, are the very living promises of better futures. And so unless every child can reach their full potential, humanity never will. We urge this committee and the New South Wales Parliament to consider our submissions as a roadmap towards reforms that ensure every child in New South Wales receives safe, high-quality early childhood education with demonstrable long-term benefits. Thank you.
Thank you. Just checking we don't have Miss Deeth back.
I am here.
Oh, you are.
Sorry, my video is refusing to work.
That is fine. Did you want to make a short opening statement as well?
Yes, I would love to. Thank
Go ahead.
you. I'm here today representing the Early Learning Care Council of Australia, which represents both not-for-profit and for-profit providers across our nation. We really welcome the opportunity to respond to the proposed amendments set out in the bill and the amendment bill, and I want to acknowledge the intent of the legislation and reinforce Sam's sentiment around the sector and the challenges that we're facing at the moment. We are very concerned with the lack of any regulatory impact consultation to date, however. Our members actively support legislative reform that strengthens safety, transparency, accountability across the sector, but we especially welcome reform that focuses on the paramount importance of the child, their safety, well-being, development. That's at the centre of what we do. I wanted to reinforce that, importantly, the qualified early childhood teachers and educators remain the single most critical guarantor of child safety. Paying tribute to our early childhood teachers and educators who overwhelmingly in their are skilled professionals who consistently demonstrate their commitment to the paramount importance of the child. So I've worked within the sector for over 40 years. I can attest that early childhood education is not an easy career. And it is far more challenging right now as the whole profession feels like they've been tarnished by the acts of a few individuals. So we really want to make sure that we protect the value the skill and safety of our dedicated workforce. But on that point, in relation to the legislation, that the critical role of national consistency is what I'd like to highlight, both now and into the future. I don't think we can underestimate that. The national approach is necessary to ameliorate the risk of fragmentation across Australia and to maintain safety and quality at the heart of the national law and regulations. I note the urgency that was talked about previously, and I share that urgency. However, I share that urgency on a nationally consistent approach. The recommendations from the independent review, the Wheeler Review, primarily provide a really timely and sensible catalyst for legislative reform, but we are concerned that the introduction of the bill at this time places New South Wales outside the current nationally consistent legislation and regulatory framework. And this happens at a time while considerable cross-jurisdiction work is underway to actually tighten and align the quality and safety provisions nationally. We're seeing jurisdictions who have sat slightly outside who are now starting to align, and I fear that we are stepping outside that if we're not working in lockstep with the other states and territories. So we welcome the commitments from the August Education Ministers' meeting to pursue the expedited amendment process to the national law by Victoria by the end of 2025. And that timeline is one that I think we should be aspiring to, if not before. And it will fast-track the implementation of improved safety and quality measures. And it means that national approach can draw on all relevant advice and input, whether it's the ASEQA review of child safety arrangements under the NQF, Victoria's Rapid Child Safety Review, as well as the New South Wales Wheeler Review. And I think they all are very important pieces of this puzzle. Where if New South Wales does deviate from the National Quality Framework law and regulations, even for noble reasons, the bill may have unintended consequences of actually weakening the system nationally, so not necessarily achieving the outcome you're hoping for. We need to make sure that we maintain that safety net for children, as we heard in the previous hearing, that we have providers who operate across jurisdictions, very different to the education sector as a whole. The early childhood sector has providers that work across all jurisdictions. They have some that work only in one, some that only work in another. We need to when I look at our sector across Australia, I see the importance of understanding each other and working together. So, in summary, if it were to progress, we'd recommend thorough engagement with other providers and stakeholders, not only in New South Wales but nationally. And it may slow slightly the process, but it will improve the legislation and any related regulation. It will also ensure there are no unintended outcomes. We are all aware that fast legislation does not mean good legislation. We need to make sure we are moving together, and we look forward to providing a written submission to the inquiry shortly.
Thank you so much, and thank you all. I do understand how short the time frame has been on this, and we really do appreciate the effort you've gone to contribute. I'm going to start with Mrs. Mitchell.
Sure. Thanks, Chair. Thank you all for your opening statements. I just wanted to go to the issue of consultation again, and I'm happy if you need to take it on notice, but just keen to understand, I guess, when you were first briefed about what was in this bill and if there was any consultation prior to it being introduced into Parliament, and I'm happy for all of you to respond if you're able to, or take it on notice. I might start with Mr. Lim, maybe.
Ms. Mitchell, as best as I can tell, we were not consulted before the bill was presented to Parliament. We had a briefing after, I think it was about 2 days after, on which we actually submitted to the New South Wales New South Wales Department of Education, I think about 23 questions with regards to the proposed bill.
Okay, thank you. I might go to Ms. Page.
Sorry, find the mute button. I am not aware of consultation prior to being alerted to it and participating in this process. So
Okay.
that said, I'm not located in New South Wales. I'm based in Canberra. Some of our members in New South Wales may have been aware of it.
Sure. Could you maybe take that on notice and just see whether they have? That'd be good.
Sure.
Thank you. Ms. D?
Thank you. We received an email that identified that the bill was going to be heard, but I think that table, I should say, the meeting though, the only opportunity we had for a conversation about it came within a very short time frame, and most people that I'm aware of, and me included, could not attend. I was actually on a plane. We only received very short notice of that consultation discussion. So no, I don't feel like we've had anywhere near the consultation that's required for the depth of this bill.
Okay, thank you. And I'll just ask one more. I'm just conscious of time and there's a lot of committee members. I think in the ECA submission, Ms. Page, but I'd be interested in the views of the other panel members as well. You talked about some of the unintended consequences just in terms of workforce and retaining quality staff, and the panel before you also spoke about that. Again, I think everyone agrees with the intent of the bill and doing everything we can to keep children safe, but concerns that you might have high quality staff just not be able to stay in the sector. Can you speak to that a little bit and what you're hearing from your members?
Yes, I mean, that is a concern in terms of some of the unintended consequences, and including, the publication of people's names and details. We're concerned about that. We're concerned about heavy penalties potentially discouraging people. I know there are whistleblower protections in the bill, I understand that, but I just think we just want to be cautious and make sure that we're not inadvertently discouraging people from raising concerns or making, particularly outside the environment of the setting itself, that we're not discouraging people from raising concerns with regulators, for example. So that was one of the provisions of the bill that we were suggesting warranted some further consultation and consideration.
Ms. Deeth, did you want to add anything on that issue?
Look, I think that we have seen, certainly from internal data, I see an increase in vacancies across our sector, even just in the most recent months since March. I think we are at a point in time that is so critical. We know that the workforce and the experienced workforce who can mentor new staff coming into the sector are the ones that we need to keep most. These are the ones I think we're at most risk of losing.
Thank you. And Mr. Lim?
Ms. Mitchell, we don't take necessarily the fact that we may not have had sufficient consultation of the bill as a problem. As you well know, when you were Minister, All these issues have been ventilated to infinitum for many, many years. And so the speed in which the bill has been presented, while perhaps incomplete still in our opinion, is welcomed. And in actual fact, it actually proves the point of a resistance in New South Wales circles that we must always do something with national consistency. The fact that the bill exists shows that New South Wales are not held hostage to the rest of the country when it comes to trying to fix problems. And if the rest of the country cannot get their act together, then New South Wales should lead. And so this bill is a good representation of that. It is not complete by any chance, but it is a good start, and more needs to occur. Still more.
But you don't have any concerns about staffing impacts or...
We already have staffing issues now.
Okay. So not specifically related to this bill, though?
Not necessarily. No. There may be consequences of this bill, yes. But sooner or later, we will have to address those as well. Okay. But this system has been in place for 14 years, so speed is of the essence.
Thank you. I'll let someone else. There's not much time. So.
I'll go to Mr. Diadam in just 1 minute. I just want to ask one real quick question. Mr. Lim, I understand that you put in like 20 questions you submitted some questions about the bill.
And another 23 more to come.
And another 23 more. Great. Okay. I also have a number of questions. I wonder if you got any answers back and if you'd be able to share them. No, not yet. Okay.
None. Having said that, we have confirmation from our lawyers with regards to the whistleblower protections. We, of course, have been overtly in favour of that. We've been calling that for quite some time.
Yeah.
We may be the only peak body that has been asking for that, particularly in light of what happened in Queensland However, the whistleblower protections do not go far enough. And also it does not have sufficient protections from a legal and industrial way for approved providers and the services themselves. It is very clear. And I thought I had a copy of the legal response. I'm more than happy to share that with you.
Yeah, that would be very interesting. Mr. Diadam.
Thank you, Chair. Ms. Deeth, I might go to you first. I mean, Mr. Lim has just made, I think, an interesting observation about the perils of waiting for the rest of the Commonwealth for New South Wales to act. I mean, I take from your contributions this morning that you think it's better for us to accept a sort of lower common denominator approach in terms of the Commonwealth rather than New South Wales leading and going forward. Mr. Lim has said that many of these issues have been ventilated for a very long time. I might invite you to offer some comment about whether you think it's worth the risk to children's safety for New South Wales to wait for the rest of the Commonwealth to actually reach agreement.
Thank you. I believe that, in fact, in Ms. Lim's comments there, is talking about the issues in Queensland that triggered this. I think I feel an immense responsibility to every child across Australia, and I think New South Wales has, in the past, led very well, particularly in the space of degree qualified early childhood teachers, going over and above the requirements of others, and that was an intentional step from New South Wales very early on in the National Quality Framework development, with the aspiration that all other jurisdictions would meet that in the long term. But what I'm saying is not that we hold back, because I think there are some very important elements of this legislation. I think we should be sharing that rather than breaking away from the National Quality Framework, because I think you can actually make a greater impact by working with the others, and we've got a commitment at the moment from the education ministers to fast track. I'd love to see another special early childhood education ministers meeting that would again fast track even more. That's the point that I'm making, rather than let's sit back and wait for the next 2 years. That's not what I'm saying at all. I'm saying yes, there's urgency, but yes, let's move lockstep.
I mean, how many months should we be waiting for the Commonwealth?
Oh, I think they've already made a commitment so far to have the first tranche, and they've got a number of improvements, a number of others on the go at the same time with rapid reviews. So I think those rapid reviews are in place. We should be considering all of those in this space.
I mean, we've heard from other stakeholders earlier about the urgency of restoring confidence to the sector.
Yes.
But your
I don't think they...
your submission is that it's still okay for us to wait even longer before we actually take any decisive action.
I don't think we're waiting. I think we're actually moving forward rather than waiting. We're moving with the others. And it's trust is something that's built not just through regulation. It's built through the sector engaging with government, the sector engaging with families. The front line are where the changes are happening and where we can make the biggest difference. And if that front line is confused by different jurisdictions and different requirements, that in my mind is problematic. We need to be working together.
Can I ask you about the Wheeler review? Are you supportive of the recommendations of the review?
Oh, look, I think there are a number of very positive recommendations, but I'd like it to be considered in keeping with the rapid review in Victoria. We've got the South Australian Royal Commission with some fabulous review recommendations as well. There are so many different reviews that we've had across our sector. It's about bringing it together rather than separating it and fragmenting it more. So I'd love to see this move fast. I'd love to see the urgency being placed very front and centre for all education ministers, but I'd like it to be done in lockstep.
Mr. Lim, I think in your earlier comments you made a suggestion that this bill was going to lead to the wholesale replacement of the National Quality Framework. Can you perhaps elaborate on that? Are you contending that the bill does that?
No, I believe that there are some in the area of public discourse who would like that to happen, that we throw the baby off with the bathwater proverbially. We don't agree with that. We see the bill as an incremental step to make a number of significant fixes. And can I contribute to the issue of New South Wales leading? While I'm sure the Deputy Premier and the Acting Minister for Education, I'm sure also Ms. Mitchell, who used to be the Minister too, would stridently advocate for New South Wales first. And last time I checked, as a migrant, the Constitution requires education to be a state responsibility, not a national responsibility. So it is quite well and truly within the New South Wales government of the day to show leadership, and I think they have. The fact that this bill exists shows that it has. And not only that, I think the government itself must have. I cannot believe the acting minister and the deputy premier would have gone without consulting their colleagues nationally. I think what's happened is New South Wales has pointed out what needs to occur. Consensus may not have been achieved, and New South Wales could not wait.
Thank you. And I might just go to Ms. Page. I think you made an observation about there being areas of oversupply. Can you perhaps speak to that rather unusual observation? I mean, the general discourse is that actually there are significant areas of undersupply and that oversupply is not actually a pervasive issue. So perhaps you could elaborate on that comment.
Yes, thank you. I'm very happy to do that. We have both. We have undersupply and oversupply. And in fact, we have undersupply and oversupply within the same region in some situations, because we have an undersupply of places available for infants and an oversupply of places available for older children. And that is because the way the childcare subsidy operates, it doesn't accommodate the additional costs of younger children. So younger children's the number of places that a lot of providers will make available for younger children is limited, and so you can have both happening at the same time. What I was highlighting is the problem with a free market approach where anybody can build an early childhood service anywhere at any time is that we do end up with this very patchy mix of services, a very diverse range of service providers, and no oversight in terms of what services are going into particular communities. And so we can have one community that is desperately undersupplied, and just down the road we can have too many services competing for a limited pool of children and families and workforce, and that is putting stress on the system, particularly workforce, but also nobody is well placed to deliver quality when we have that dramatic mismatch between supply and demand. And these are issues that go to the need for system stewardship, particularly as we build out a universal system and we move away from that free market approach to more of a planned approach where we care about who the providers are and we care about where the services are going, and we make sure that all children have access to high quality service provision.
Thank you. I might yield, Chair.
Thank you. Ms Mihalik, did you?
Just very quickly, thank you to all three of you for your contribution today. I just wanted to just clarify, were people, and maybe we can just start with yourself, Mr Lim, you're all aware that the Wheeler inquiry was on foot, right? I mean, was anyone surprised that there was going to be a report that would actually provide recommendations for the government, for the New South Wales government to act swiftly? You were aware of it, Mr Lim?
Of course.
Of course. Is that the same with Miss Page and Miss Death?
Correct.
Could I just ask you to confirm that you were well and truly aware that the Wheeler inquiry was on foot when it was announced, and that there would be significant recommendations being posed to the New South Wales government to act?
Yes.
Yes. All right. Well, that's, I mean, and I think this is what the government's done in proposing a bill, and there is an opportunity now, rather than laying this on the table and waiting for the Commonwealth, I think there's an opportunity now if all of you as chief executive officers could make suggestions, and I think some of you, and I think Mr Lim has already made a submission and has noted that he's going to add some extra questions. There's an opportunity now to really give this committee something to work with by any suggested amendments, for example. I'm sure many of you have access to legal access to lawyers, or yourselves as advocates could have a good look at the legislation, and I just ask in your submissions or anything that you want to table to the committee that you perhaps make some specific recommendations that you'd like to see amended in this particular legislation. Thank you.
Mr Lim, go ahead.
To give you an example, Ms. Mihalik, and New South Wales isn't the first to lead. In fact, I'll give you a very practical live example that Victoria led, and the rest hadn't followed yet. In the case of insurance, Regulation 29 requires every service to actually have a appropriate insurance. Victoria went further than that and stipulated that it had insurance, not just public liability per service, but also child abuse insurance per service. Yet in New South Wales, anecdotal evidence suggests that that may not be the case in New South Wales, let alone the rest of the country, and that there may be some approved providers out there that are using one insurance policy to cover multiple services. Now, thankfully, the New South Wales Regulatory Authority was alerted by us about this, and the New South Wales Regulatory Authority did try to fix the policy that was published, and we are very appreciative of Sharon Gadu, who did that for us. But the practice, anecdotally, seems to suggest that it still happens. And so one of our points in the submission is, well, we're not talking about rules per se. We're talking about actually how do you make sure that it actually does happen. And so Victoria has already led in some ways. Why hasn't New South Wales led in that sense? So maybe it's high time, for example, that New South Wales start leading too. We are the premier state.
Can I just clarify your point there? Because this bill does
not talk about that.
It doesn't, yeah.
Sorry, this bill does exclude the ability for anyone to have insurance or professional, insurance against liability under the laws.
This is to do with appropriate public liability business insurance.
Yes.
Right.
So this bill has a provision in it.
Yeah.
That's
but it doesn't, in the practice of it.
Right.
Right. Which Victoria leads the way. In the practice of it, it is guaranteed basically that every service has its own policy.
Yeah. But
we seem to be seeing that some services do not. And I've got an example right here.
Okay, but this bill a provision of this bill is that nobody can have insurance against liability under the national law. Are you supportive of that?
No.
Right.
It has to have. I mean, how do you protect children then, in that sense?
I think the bill goes to insurance against penalties to be paid. The insurance that Mr. Lim is talking about is a different nature of insurance.
Yeah, it's not coming.
But I do think there are differences across states and territories, and I agree. I agree that New South Wales has led in terms of staffing qualifications and the role of teachers within services, for example. I don't think any of us would disagree with some scope for difference across. It's more about whether any of the amendments in this bill would have an unintended consequence, would not give you the objective that you're trying to achieve. That's the piece that we would like a little bit more time to consider. Not that we're objecting to them at all, and in our submission you can see that we are supportive both of the bill overall and the specific amendments, but we just want to make sure that there's nothing that would inadvertently cause a different outcome to the outcome you're wanting to achieve.
So can I just clarify then the position, because
time, Chair.
Thank you, Mr. Diadam. So just to end with, I just want to clarify the position here, which is putting to one side the concerns you have about New South Wales going alone. If we put that to one side, if we're just looking at this bill, I think you're all agreed that there are some really good things in here and some good intentions, but it's about getting the drafting right and making sure that those provisions don't have unintended consequences that you're asking for further consultation for. Is that correct?
Well, hang on. Are you actually asking?
I'm asking if that's correct.
I thought they were just happy to provide submissions. Is that right?
No. From an ACA New South Wales perspective, the bill's just a good first step.
Okay.
The independent authority, independent New South Wales regulatory authority that's coming into the future is also a good first step. I think we're not asking the bigger questions. Is the overall system fit for purpose? Is it predictable? Does it work? The existing 9 national laws that the regulatory authority already has, which the bill does not touch on.
Yeah.
Why haven't those 9 specific laws within the national law been used consistently to regulate the sector?
Okay, but do you have problems with any part of this bill, or would you just want it to just be put through?
The questions about the current bill, there still needs to be more detail that's required,
Right.
yes.
Okay.
But it does not go far enough,
Yeah.
is what we're saying. And so our submission, which has finally been sent,
Thank you.
does not, will outline where are the gaps. And we've been asking for these to be considered for many, many, many years.
We are out of time, unfortunately, but to the extent there are questions taken on notice or supplementary questions, the Committee Secretary will be in touch. I understand there's a shorter time frame for that, but that does conclude our time with you. Thank you very much for making yourselves available.
Thank you.
Thank you.
Thank you.
Saw on the front page of the paper.
Professor Newman can hear us.
Yes, I can.
Excellent, thank you. We will commence. Thank you very much for your attendance today at such short notice. If I could ask you to please state your name and position title and then swear either the oath or the affirmation.
My name is Linda Newman and I'm an Honorary Associate Professor at the University of Newcastle. I'll state the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And did you want to begin with a short opening statement?
Yes, I will. Thank you for the opportunity to comment on the National Law Amendment Bill 2025. This proposal and plan changes to the Children Education and Care Services National Law Application Amendment Bill 25 comes at a time in the history of early childhood education and care sector when things must change, and I've been able to hear some of the evidence this morning. It's very clear. It has come at a time when the general public have become aware of the importance of early childhood education and care, but sadly, as revealed by the ABC television program Four Corners, not all centres have children's best interests at the forefront of their operations, with harms occurring to very young children at an alarming rate. It's gratifying to see that the New South Wales Government and the Federal Government have at last grasped the importance of children, their safety, and the role of the early childhood education and care sector. Importantly, the on-the-ground users of the final amended legislation, early childhood educators, must be given the opportunity to consult on the final draft of the legislation before new law is formally adopted. Within this context, two primary matters are of concern to me. The first is the haste, and we've heard other people talk about that this morning. That's evident. While congratulating that, it's also something that we need to consider carefully, I think, in our discussions. As state and federal governments attend to make necessary changes and convince the public that they are addressing critical issues. Much of this work, including the law amendment proposal addressed here, is being done in the absence of input from the very people who work with the mandated regulations on a daily basis. These are the people who are governed by the law and, more importantly, know how the regulations do and do not play out on the floor, as we tend to say within the profession, as they work with children and families. Secondly, while law changes are necessary, they're not enough. We're witnessing a top-down focus on change with emphasis on laws, rules, policies and practices that are governing, controlling and punitive. We are not yet seeing bottom-up changes to better prepare and support the people who do the work that is governed. While there is a lack of respect and recognition for early childhood educators in the form of revised salary scales, improved professional preparation, ongoing supported professional learning, and supported well-educated leadership, it is hard to see how policy and governance changes can produce the shifts in the quality of education and care that the citizenry of Australia requires, and is falling for. And just quickly to preface what is to come, I will tell or remind the members that this is an individual submission. I've been working in the early childhood sector for more than 40 years across a range of roles. I have worked on the floor, as we say, governed by the previous versions of the regulation, but I do not currently do this. I'm a semi-retired early childhood teacher, lecturer and researcher. I'm not a lawyer and therefore cannot give fully informed opinion on all the amended proposals. I also wish to point out that the amount of time made available, as we've heard already, was made it difficult for full and careful consideration of the bill. Thank you.
Thank you so much. And I know that when you appeared before our other inquiry, your experience as both a teacher, somebody who sat on boards of services, and then also as an academic makes you a very useful person to talk to about the impact of some of these things. Keeping in mind you're not a lawyer, I think just understanding the sort of real life impact of things is really useful. So in that, I guess in that spirit, I wanted to speak with you particularly about the new proposed offence of inappropriate conduct, which I view as very well intentioned, but I worry about the wording. We had some questions earlier about what could be, where the, I guess, problems could arise in people not understanding or having different ideas of what an inappropriate conduct is. And I know I've spoken to educators who say that in some contexts, tickling a child's, a baby's belly when you're changing their nappy could be completely innocent. And in other cases, knowing what you know about a particular educator, that could actually be a bit sinister, as an example. Can you give us some examples of where somebody might think something is potentially sexual or inappropriate, where someone else might not, and what we could do to sort of better define those range of behaviours?
Yeah, bearing in mind that I'm very well aware that we can't have a 5-page definition in a bill or a law, just some examples that come to mind, and I think it points out, and something that we need to keep in mind is that these things can be very subjective, and they can have a cultural basis in that level of subjectivity, an experience basis, a qualification and training basis. So there are a lot of different things that can come into it. One example that jumps into mind for me was when I was in a position for 6 years of being responsible for the professional experience of student teachers who went out into the field. And so part of that role was that any students who had concerns for any reason when they were out in the field were to come back to me and talk those through and work out what we were to do about it. And so I did hear all sorts of stories over those years, and it actually led to my professional doctorate work in ethics, professional ethics. And in this instance, some students came back from a centre that I didn't know the actual centre, but I knew the organisation very well, and it was a highly regarded organisation. And they came back and told me that children were being tied up. And I was, of course, horrified and surprised that that sort of a report would come from that organisation. And so, again, as part of my role, what I needed to do was to directly contact the organisation and find out the other side of the story. And it had turned out in that instance that they were using, I can't quite remember what they were called now, but Joey chairs or something. And they were like a transportable high chair for young toddlers so that they could sit on the normal small dining chairs that the children use to eat at the table. So it was like a cloth type organisation that you put over the back of the chair, and then the child sat into the seat and had some safety straps around them. So I suppose one interpretation was that they were being tied up, but the other was that they were being kept safe in that situation. So we were able to work through that one fairly easily. But just to make the point that it is subjective, another thing that comes to mind when you talk about, tickling a child's belly is that there's been some emphasis in certain quarters in recent years about the importance of rough and tumble play, for example, and often this is focused on programs about dads and children and encouraging men to engage in rough and tumble play with children to help them learn about appropriate ways of being able to say, stop, I don't like it anymore, and the other person involved in the play, the adult in this instance, or a bigger child, needs to be respectful of that instruction to stop. So I can see that there can be lots and lots of ambiguities there. Kissing children, that's something that I've done some early childhood work in another country. And one of the first things we noticed was that the educators were kissing the children left, right and centre and all over their faces and all over their bodies. And at first we were shocked by that, but that was certainly appropriate in that culture. So,
can I ask you then, I think, so there's the sort of definitional issue, but then also at the moment we have the offences in relation to, failing to keep a child safe from harm. But when it comes to liability on a nominated supervisor, the obligation on a nominated supervisor is to ensure that every reasonable precaution is taken to ensure that a child isn't subjected to harm. So if there's an educator on, under their watch who has done the wrong thing and they haven't actually taken, known about and taken the action that they needed to take, that they can also be held liable. But under this new offence, it's actually saying that the nominated supervisor must simply ensure that every child isn't subjected to inappropriate conduct. It doesn't have that step of taking reasonable precautions. And it's been pointed out to me that you could have a nominated supervisor who, really just had absolutely no idea, had never seen anything, hadn't seen it happening, could even have a casual educator being on board that day, and it's happened.
Yes.
And then they would be held liable under this section when they could actually do nothing to prevent it. Do you think that goes too far? Should that be, I guess, amended to be more in the lines of taking precautions? And I guess, what does that taking precautions look like in the context of current offences? How could it play out?
I think obviously somebody has to take responsibility, and this issue has actually been raised with me by people out in the field concerned about this. And somebody has to take responsibility. And in, a big organisation, a CEO is where the buck stops, or whatever in other sort of areas of professions. One of the things that I think can be is necessary, but seems to be slipping away in the current climate, is the support of the whole team. And so, yes, the person who has the legislative responsibility is the one where the buck stops. But that person is supported by a team, and there needs to be measures taken so that there's excellent communication across the team, excellent processes across the team, so that everybody knows what everybody else is doing. And in that instance, then I think, maybe it's not too much. It shouldn't be too much.
Sorry, what shouldn't be too much?
That the nominated supervisor takes the responsibility.
Yeah, okay. I'll go to Mr. Diadam.
Thank you, Chair. Thank you, Ms. Newman. I want to perhaps start by asking whether you accept the Wheeler recommendation around paramountcy, that the absolute obligation of everyone in the sector is to give primacy to the safety of children. Is that something that you accept?
Yes.
So then I want to go to the evidence you've provided around the question of inappropriate conduct. I mean, the framing of the provision is really about where we accept the balance of risk should sit, and that the provisions obviously have a reliance on what a reasonable person would accept, and if there's some ambiguity, then the default is that the conduct should be avoided. Do you accept that that's a reasonable measure in light of the idea around the paramountcy of child safety, that if you're in doubt that it might be inappropriate, then you shouldn't do the conduct, and that a reasonable person should understand that that's the intent, and if there's ambiguity, then the balance of risk should be in favour of avoiding the conduct rather than allowing the risk with the potential that it might place children in harm. What do you say to that proposition?
Yes, I do agree with you. I think where the complicating factor comes in is the idea of the reasonable person at the moment in the context of a field where there is a huge shortage of full-time regular early childhood educators, difficult to get people with experience. We have a massive range of qualifications. We have, I think probably, I don't know if it is in all organisations, but I know in many organisations we're increasingly seeing wonderful people come in who don't have English as a first language. And so what I think we need to explore and work further with is, you can't ensure, but doing the best we can possibly do to make sure that all people working with children in early childhood centres are appropriately prepared to be that reasonable person and have a full level of understanding. And that's where, when I read the amendments, I was concerned about some of the wording. Ideally, the people who are working every day across the whole spectrum of Certificate 3 educators through to degree qualified teachers should know those regulations and laws and should be able to understand them. And so that was my concern with some of the wording.
And so,
Not particularly this one, but...
So accepting that doesn't, I mean, any kind of further weakening of that provision or attempt to sort of elaborate on it, that doesn't resolve the fundamental problem, which is the obligation on the providers to make sure that their staff understand their obligations.
Yes.
And ultimately, this question around the default, whether if you're in doubt, then don't do the conduct, right? Like that should be the kind of guide. And that's not that complicated in terms of ordinary staff day-to-day having to interpret their responsibilities. Do you accept that that's the case?
I'm not advocating for a weakening, but I would just like to ensure that there's clarity, that the people who are working with it can understand.
So what type of clarity would you make? What clarification would you make to that provision?
I think it could be. I haven't attempted to do this myself, but I think it could be clarified perhaps with a few more words about what that actually means in practice. What's inappropriate? Something that I won't attempt to do that here now, but I think it could be made a little clearer.
Are you aware that there's also further initiatives around a nationally agreed professional development to support the implementation of this change?
No, I haven't heard about that.
Right.
That's good. Yeah, that's good.
Thank you, Chair. I might allow others to ask questions.
Thank you. I'll just ask, can I just ask one quick one?
Yeah.
Sorry, just a quick one. There's a lot, I guess when we're talking about child safety, in our other inquiry, there was a lot of evidence about, there are structural factors that are leading to some places being statistically more or less safe than others. And it's been put to me that this bill, although well-intentioned, is very much about sort of punishing wrongdoers rather than encouraging practices and structures that we know create a safer environment to begin with. Do you see anything in this bill that actually encourages existing practices of safety or, does anything to do you have any concerns that it will actually prevent some of those who are already sort of doing the right thing from being able to focus and continue to focus on that instead of being sort of bogged down in a lot of these other changes?
Possibly. People are, I think, the people that I've spoken to, when I say people, the small number of people that I've been able to speak to in the field and the experiences I've had are tired, morale is low, people are nervous about changes, and so the idea of working under CCTV surveillance and fines and other issues like that, I think does make people nervous. I don't think it would negatively affect their practice necessarily, but I don't think it's helping the self-image of the early childhood educators who feel that some of these initiatives are taking away from their views of themselves as trusted professionals. The issue of trust seems to come up. And I'm not saying they shouldn't happen either, but it's a fraught, complex issue, I think.
There's cameras everywhere now.
Yeah.
There's cameras on us as MPs.
Yeah.
Mrs. Mitchell?
Yeah.
Thanks, Chair. Professor Newman, in your submission, you talked a little bit about the powers of the regulatory authority expanding, and you made a bit of a comment just about, I guess, the qualification of people who are going to do sort of assessments and ratings. We had some evidence earlier just about sometimes inconsistencies in terms of what, a particular authorised officer will see as a breach versus another one.
Yes.
I guess in terms of what's in the bill, is there any sort of further comment you could make around how that could be done in a way that is actually consistently applied and, in your experience, sort of best practice when it comes to that?
Yeah, I'm not aware of what sort of training those people have, but I am aware that some of the people who do come out have diploma level qualifications. And I recall in our last inquiry presentations, my colleague Marianne Fennick made the point that they should be degree qualified educators, because I have heard quite a lot of stories of people being rated down on a particular area where the authorised officer hasn't necessarily understood the work that's been happening in the centre at I suppose, a higher cognitive level of research or programming and practice. And so, if there was a suggestion to be made, and it may not be practicable at this point in time, but I would advocate for the people who are coming out and doing that job to have at least a degree in early childhood education.
And then just one more, if I can, Chair. One of the other issues that we've had raised just goes to issues around the fines and the penalties. And obviously, everyone agrees when it comes to child safety, you need to have as much impossible as you can to deter poor operators. But there was some evidence earlier just about sort of, I guess, more minor administrative breaches, but that sort of hasn't been distinguished in the bill in terms of, maybe not displaying a piece of paper versus something very serious to a child. Would, in your, I guess, professional opinion, do you think that there should be a bit of a distinction between those when it comes to breaches and then the penalties that are linked to them?
Yes, I do. I do think so. I can give you a recent example in my own experience where in one of those big heavy rainstorms we had a couple of weeks ago, an overhead gutter over a veranda sprung a leak. And that centre was part of an organisation where they had to have it applied to be fixed by an outside person. They couldn't just, ring a plumber on the spot. And the authorised officer came a couple of days later and said, we're going to issue you with a notice because the gutter's leaking onto the veranda. And they'd done what they could to kind of keep the people away from it and put a bucket under it, all those sorts of things. And they said, well, we've applied to have it fixed and they're going to be here in a couple of days. But nevertheless, that went forward. Now, I wouldn't like to see somebody fined for something like that.
Thank you. I'll let someone.
Thank you. Did you have a question, Ms. Mahalik?
Just very quickly, Professor Newman. So, obviously you've made it clear that you would like the bill to be written a little bit more in plain English, but I suppose you do accept that the Parliamentary Council's doing its best just to write it in a way that they need to legally. It still needs to be guided by the way the Office of Parliamentary Counsel needs to have legislation worded. So did you have anything, I've seen your submission, did you have anything more that you might want, other than what you've suggested today? Is there any other suggestions that you do want to make, or are you satisfied that we should still proceed with the bill as swiftly as possible and do you agree with that?
Yes, I do agree with that. I'm very pleased to see things happening quickly. My only concern is that in haste we might make some mistakes.
Yeah, so this is an opportunity now that we could make a few amendments if necessary. And and if you do have any suggestions, please email the committee. I think that would be great. But all right, I don't have anything else to add. Thank you.
I've just got one final one, and that's just, I guess, how does it work on the ground when you get changes? As someone else said before, the national law is a living document. There's been changes before made to it, but when those changes come through, what does that mean then for somebody who's maybe not one of those very large providers, but if you've got, someone who's only got a couple of services, what's the kind of procedural burden on those services? And, is there perhaps a request for a bit of funding to help implement new reforms or anything like that on behalf of those smaller players?
One of the big issues, I think, is time. And, of course, we can't create more time. But to be able to provide any sort of professional learning development for staff in a centre who are working on perhaps split shifts and crossing over each other when they come in and out of the centre over a long day, is finding that time. And so certainly if there was some financial help to be able to bring in some casual staff members to give staff time to get together and undertake professional learning, that would be a very, very big help. It's very difficult to find the time to get people together. I'm doing some work at the moment, some voluntary work where I'm mentoring some directors, and the number of times the meetings are cancelled because the director has to go on the floor, again, as we say, because they can't get enough casual staff members to cover the ratios. So time is a really big problem, and any financial assistance to be able to have a few extra bodies around to help with that would certainly be wonderful.
I've heard that from a lot of educators, that they have to do all of that development and training in the evenings.
In their own time, in the evening or on Saturdays, or yeah.
So some sort of, I guess, obligation put on providers to allow time for workers, but then for those smaller players, particularly for not-for-profits, to maybe have a little bit of financial support in an ideal world.
And not too many other professionals have to do professional learning, professional development in the way early childhood educators do. It's not being sent off for a weekend somewhere beautiful, or, given lovely catering and whatnot. It's squishing into a tiny little staff room that doesn't have enough room for them, and if they're lucky, they might get a pizza slung at them at 7 or 8 o'clock at night to keep them going.
Thank you. That's incredibly useful, sort of on the ground experience and evidence for us. Thank you very much for your time, and again, apologies for the very short turnaround in asking you to prepare and come along today, but it's been very useful for us.
Thank you.
That concludes our
if I
session.
could just...
Oh, go ahead.
If I could just also just apologise. I think I incorrectly addressed Associate Professor Newman, so I just wanted to... I think I referred to you as Miss Newman, so I just wanted to acknowledge that I incorrectly addressed you. So
I certainly did not notice that, and I incorrectly addressed Mrs. Mitchell in the last inquiry, so we're even.
I didn't even notice, so it's fine.
Felt terrible.
I don't know.
Very much.
All right. Well, thank you very much. The Committee Secretariat will be in touch in relation to further questions and questions taken on notice. Thank you.
Thank you. Thank you. Bye.
Oh my goodness.
I thought you were vegan. Why did we have all this meat?
I don't know. I can't have any of that cream. All right. So we now welcome our next witnesses, 15 minutes earlier than they were scheduled. Thank you very much for accommodating the committee's adjusted timing. If I could ask you to please start on my left and state your name and position title, and then swear either the oath or the affirmation.
My name is Carol Matthews. I'm the New South Wales ACT Branch Secretary of the Independent Education Union, and I would like to take the oath. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
I am Lisa James. I'm an early childhood organiser at the Independent Education Union, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. And would you like to commence with a short opening statement?
Okay. Well, first of all, can I thank the committee for accommodating me at short notice. We obviously prepared this submission quite quickly, and Lisa had a lot to do with the writing of the submission. But when I reviewed the submission and the bill, I was horrified, I have to say, as to the implications for our members of the bill. And so I just thought it was really important that I came down in person to talk about that. And I think the issues that I would say, speaking broad, so first of all, our union absolutely supports improving child safety. So we don't have a problem about that. And there are quite a few measures in the bill which we point out in our submission that we support. But the increase in penalties for nominated supervisors of to $34,000 in most cases, we think in a situation where there is strict liability, in other words, there is no requirement to prove any type of culpability, we think is simply unreasonable. And a nominated supervisor is the supervisor, even if they're on leave, absent from the service, or otherwise not at the service. And to suggest that someone could be liable for a fine of $34,000, which they would pay personally, if there was something which happened at the centre which was not their fault, basically. So that's the position we take. Obviously, happy to talk more about the specific offences that we're concerned about. We're also concerned about the disciplinary proceedings process. Our members already feel very uncomfortable when the regulatory authority investigates an allegation against them. So compared to the procedures in schools, where if there's an allegation, there tends to be a very clear procedure where it's never pleasant, but the members are clear about their rights and can be represented. Our experience with regulatory authority investigations is that people feel they don't have a lot of rights and they are very anxious about them. To suggest that an offence could be determined by an independent arbiter appointed by the minister and that person could award a fine of $34,000 against one of our members seems concerning. And it's also unclear what rights the employee would have in that circumstance. There's nothing in the bill which tells you what rights they have. Do they have the right to be represented by the union, by a lawyer? Do they have the right to see the evidence underlying the allegations? So we're concerned about the expansion of the range of offences, the tripling of the size of the penalties, and also the procedures that apply, which could lead to a person being fined. And I notice even the PIN notices, the infringements, they can still be fined 50% of the amount, a lot more than a traffic fine. So $17,000 for a matter which seems to be dealt with administratively without any process. So in summary, that's our concerns.
Thank you. Did you also want to say something, Ms.
Yes,
James?
thank you. We support the overarching principle of ensuring the best interests and safety of children are paramount in all decisions. However, to effectively represent the rights, safety and best interests of young children attending early learning, it's imperative to address staffing levels. We consider that the ratios are just not adequate for teachers and educators to perform all of the required tasks during the day. Despite a number of the proposed changes to the legislation carry an increased compliance burdens that we are concerned will fall on teachers and educator-nominated supervisors, as they are responsible for the day-to-day running of the service. The significant increases in fines for the breaches of the national law for individuals who are nominated supervisors who are teachers or educators creates a substantial financial risk that is disproportionate to their income and capacity to pay, and is likely to further exacerbate existing workplace shortages, high levels of stress and low morale. As some providers are like companies like G8, the company is responsible for the payment of a fine. So a CEO remunerated on a $3 million package per annum is not personally liable to pay a fine. Perversely, a teacher or educator being paid as little as the award rate could personally be liable for fines of $32,400 per offence, and they can add multiple offences to a fine. In addition, the introduction of a significant number of new offences and substantially higher fines are likely to disproportionately affect not-for-profit providers, which operate on tight budgets and have limited financial reserves.
Thank you. If we could go first to that penalties issue. So I think we can all agree on one scale, like on one end, that the really large providers, that that the buck stops with them. The buck stops with the person at the top. Absolutely, let's find them. It seems kind of uncontroversial. Then we have a little bit more controversy when we come to what about those community owned. I'd love to know what happens in a government preschool when the approved provider is actually, I think, probably the secretary. Is he getting fined? I don't know. We'll ask him later. And then as we sort of come down to, obviously, an educator who has done the wrong thing, we would, I think most people would expect that fine should apply, and I think we can sort of get on board with that, although subject to some of those review provisions, etc., which you can talk about. But I just want you to focus on the nominated supervisor role, because I think that gets misunderstood. Now, it's my understanding that they don't necessarily get a higher wage for that role.
No, there's no allowance in the awards for a nominated supervisor.
Right, so it's not, you don't get paid more when you're a nominated supervisor. We've heard in other evidence, in our other inquiry, that sometimes it can be like, someone who's like 19, you get this big provider who's just nominated them, and unless they say no explicitly, they just become the nominated supervisor. Many of them feel obliged, otherwise they might lose their jobs. Is that your understanding?
They do need to agree, but yes, that many of them do feel obliged, and there's no sort of... They don't have to have, a bachelor degree or a diploma. Some of them are even certificate 3s, and then they're put in that position.
Okay, so they're not necessarily the people that have the power to do things like make sure that everybody has child protection training or the other training that's being mandated under here. Do you think that should be something that really does attract liability for a nominated supervisor as opposed to the actual approved provider and the companies?
Yeah, I think that's a problem because we, in some of the for-profits, we see at the smaller ones that the owner will say they're the approved provider, they're the director of the service, but then they'll choose a teacher or an educator to be the nominated supervisor. That nominated supervisor is not in charge of employing additional staff or sometimes even interviewing the staff, and yet they're being held liable for the decisions that are being made.
Yeah, okay. And then, I don't know if you were listening when I was asking the previous witness about this new offence. Unlike the offence of, so at the moment under the law, the nominated supervisor can be held responsible if they haven't taken all reasonable precautions to keep children safe. I think that's the wording, which can then be interpreted as, obviously, if they're not there or if they didn't know about it, then there can be some sort of leeway for them.
Gone through the policy in a staff meeting, explained and let people ask questions, etc. Yeah.
Right, as opposed to this provision, which says that if an educator is found to have engaged in inappropriate conduct, the nominated supervisor is just liable.
Yes.
Do you see that as a problem?
Yes, definitely. You can, the nominated supervisor might explain the policies, tell everyone they need to complete child protection training, but they're not there physically able to stop an employee from harming a child if that employee has the intention to do so. And I think I mentioned the last time I was here, we've had teachers that are nominated supervisors who have felt because there's such a turnaround in staff, they don't have any stable qualified staffing, they haven't been able to take annual leave. One of them for 3 years, because she said, when I'm not on the premises, I'm responsible for what these casuals are doing, and I'm not confident that they understand all the processes and that an incident's not going to happen when I'm not there.
So, unamended, do you think that this bill would have consequences on workforce retention and attraction within the sector?
Certainly, people like teachers and diplomas, I imagine, would be reluctant to take on a director or nominated supervisor role. They might be willing to remain as teachers or educators in the room, but it's not likely they're going to want to take more senior leadership roles in a service.
Are you aware of any, firstly, were you consulted at all in relation to this bill?
No.
No.
Are you aware of any of the unions being consulted?
No.
The department or the minister has a advisory group, early childhood advisory group, they provided us with the names of the people on that group in the latest budget estimates. There's no unions on there or worker representatives on that group. Is that something that you've asked to join?
We didn't even know it existed. So I meet with the minister probably on about a quarterly basis and can raise issues with her at those meetings in relation to early childhood. And I also, our union has a seat on the pre-education ministers' consultations, which occur prior to those education minister meetings. But I had no idea there was an early childhood advisory group.
Does it concern you that, I guess, what are the real world consequences when legislation like this isn't subject to a consultation process where parties such as yourself or workers are able to actually talk about the impacts on the ground?
Look, I think it's really serious. And can I give quite a concrete example? Take an example where an educator did something which was contrary to the national law, which required reporting. It might be an assault on a child, pulling, pushing, whatever. Under these amendments, and indeed under the existing law, a nominated supervisor might be reluctant to report that matter because, as you've pointed out, the mere fact of the incident occurring also creates an offence for the reporting person, as it does for the approved provider. So it just seems to be an anomalous provision that in a system, or clearly the bill is intended to improve child safety and improve reporting of matters, but if I was a nominated supervisor, I would be really nervous if, under the current wording of the bill, which is in most cases that the nominated supervisor must insure something, and therefore if there's a breach they clearly haven't insured it, I would be really nervous if I was going to be reporting a matter which potentially would lead to me being fined $34,000 and my employer being fined anywhere between, I didn't really look at the fines for approved providers, but many of those are over $100,000. It just seems to lack a thoughtful consideration of how those large penalties would operate in practice and what the consequences would be of those strict liability provisions.
So those provisions could actually lead to, for perhaps understandable reasons at an individual level, but a lack of reporting by setting up incentives to not report because you're so worried about the consequences, not only on yourself but on the entity that you're working for.
Yes, and I think, I think our members, qualified teachers, are really committed to reporting and transparency, but it is a very big burden to bear that when you report a matter in accordance with a legal requirement, you are then potentially liable for these penalties, and your employer is liable for the penalties.
Just before I hand over to my colleagues, I guess I've been looking at this and trying to compare it to something like the WHS Act, where you've got a PCBU structure where, ultimately the obligations and penalties sit with the PCBU, but everybody has responsibilities and obligations as well. It's just, I guess it's that definition of PCBU is more flexible and it's kind of relatively... Do you think that sort of structure or system that applies in work health and safety is really sort of the kind of thing we should be getting at here, where you've got that sort of ultimate responsibility sitting with the people who make the decisions? Everyone still has an obligation to report and to do what they need to do, but I guess there's a more nuanced understanding of where liability should sit.
Look, I don't really know. I mean, when you look at the model, obviously you can compare it with the WHS model. I'm not sure exactly how it should operate, but I agree with what Ms. James just said, which is that it is ironic or unconscionable, really, that someone who is not responsible in some cases for staffing decisions or hiring and firing decisions or decisions about the conduct of training could be liable for a breach in those areas. Whereas a person conducting a business under the WHS legislation would normally have all of that authority. Whereas in the early childhood education space, some of those roles are split between the approved provider, the nominated supervisor, and the nominated supervisor. So the nominated supervisor may not have the authority to make decisions which would relate, which would keep children safe and help minimise the problem.
So liability and responsibility needs to sit alongside authority and control.
Absolutely. And can I also just raise another peripheral issue, but the issue about training. We, of course, support mandatory child protection training, but the bill doesn't make clear how often that has to be conducted. And if a service is employing a casual, for example, how do they ensure that person has child protection training? Does it mean they have to train that person in every engagement? Or would there be some sort of register of child protection training? I don't know how a nominated supervisor or an employer can easily check the records of someone who is a casual employee, might say, I've done the training at my last employer. Well, how is that enforced? And we think that issue needs to be looked at, but we also think it should be clearer how often the training needs to be conducted, because as I read the bill, it just says there's a requirement to be trained. Does that mean once every 5 years? Whereas you could simply say the employer will conduct regular annual child protection training, and that shall take every effort to ensure that all employees are familiar with the principles, even if they haven't done that training once a year.
I'll go to Mrs. Mitchell and then to Mr.
I was going to
Diana.
ask about the training, and you did sort of just answer my question a bit then. Ms Matthews, but you also talk in your submission, and it might be better put to Ms James, I'm happy for either or, but just about the impact of volunteers. And I guess I'm just thinking about the community preschool sector, where obviously you've got quite often parent involvement in running the governance side of things. They might be in and out of services providing support. Any sort of particular concerns about how what's in this could impact, your average mum or dad who's volunteering at their local child's preschool?
Well, yes, as in they would have to do the training before they're able to actually come. And, we used to get parents to come in and sing with the children, participate in music, or do cooking experiences with the children from their cultures from home. And you do have parents from culturally and linguistically diverse backgrounds. So explaining to them they have to do this training, how much of that training they're actually understanding, how they're going to access it, are they paying for it? I know some of our members have told me that their employers told them they want to update their child protection training every year, and the full course with some providers is $300, and they expect the employees to pay. So are we going to expect parents to pay that because they want to come and volunteer at the preschool? Or
yeah, so more clarity around what that actually means in terms of, and then again, I'm thinking sort of more about, the local board, the governance side of things, which often will have parent or community people in that role. Do you see an impact for them with what's in this legislation as well? Because it's often hard to get people to fill that as well, which is another challenge.
It is, and technically they're the approved provider, so theoretically the management committee would be held liable for fines as well if somebody on the premises had not completed that training because they hadn't ensured that they had. And they are volunteers with, usually full or part-time jobs in addition to.
And that's not just for the child protection training, it's everything within this bill where there's increased penalties that will come back to the parent or community volunteer who is on that.
Yeah, if they're the approved
board.
Provider, yes. And most of those standalone community-based services, that is the case, yes.
Yeah, okay, thank you.
Mr. Diana.
Thank you, Chair. I wanted to perhaps ask about you've spoken about the issue around the fines and the liability, and I wanted to put to you that you would accept that in light of the reported events, the horrible instances that have appeared in the media, around the mistreatment of children, that there's obviously a sense that we need to take action that is proportionate to the heightened sense of risk that clearly is evident. Do you accept the recommendation from Wheeler around the paramountcy of child safety? I assume. I'll start with that question.
All right, I might answer that one. Look, I do in principle, I just don't know what it means. So what I would say is, are we saying in a for-profit service, or a not-for-profit service for that matter, that in deciding, for example, whether to have an additional staff member in a room, because we've raised some issues in relation to ratios in our submission, that in making that decision, the paramount consideration is the interest of the child. So yes, you must have an additional staff member. But that clearly doesn't mean that, because obviously there must be some discretion for a provider to work out what is actually required, and to not make not provide a roles, I don't really like this expression, but not provide the absolute maximum level of staffing, even though that would without doubt be in the best interest of the child. So there is always a consideration of cost in making those decisions. So in other words, we won't employ an extra person in this room, we might employ an extra person in the other room, or we may not employ an extra person at all, because although it would be helpful, we don't think we can afford it. So I support in theory the concept, but I don't actually know how it applies in an individual in relation to a particular decision.
Well, clearly operators have to make an assessment of the relevant risk that they see in terms of the arrangements that they have operating in their service. And that risk evaluation, that risk assessment, will obviously be fine-tuned based on the various options that are available to them, including the constraints applied through the financial kind of constraints that they operate under. I suppose I wanted to come to the penalties question, because the framework from my observation is it's devolving the responsibility in a way that all players, all people involved in the sector, from the lowest to the highest, have to have a heightened sense of awareness of the potential risk. And I want to pose to you that the increased penalties at an individual level are really a device to ensure that in making a calculation about when a person is placed under pressure to overlook a risk, they choose to actually say no, which is obviously the power that's left with any kind of participant in the system, is that they can look at a situation and say, this presents a risk to children, and so I'm not prepared to do this. Because one, I have now a heightened level of liability, so I've got a tangible reason to say no, but that's a mechanism to empower that individual to say no to those who are potentially asking them to take unreasonable risks that put children's safety at risk. What do you say to that? Do you accept that that's part of the logic of the framework that's being put in place by this bill?
I think that I would probably say that I don't really see it like that. I see it as identifying, if I can be blunt about it, I see it as the government shouldn't. It looks like the solution to child safety is fining people, and that to look like we're serious about child safety, we have to increase the fines. The fines are already $11,000. So why, and these are people on low income, sometimes they end up getting legal representation. That a person who is facing an offence under the current Act, it can be horrific, the personal impact on them. So that's with an $11,000 fine. So I'm not sure that the fines need to go to $34,000 to make people concentrate. I think.
But do you accept that in the choice that's being made between protecting children and the imposition on individual workers, that the policy intent is really to fall on the side of, greater vigilance for child safety rather than prioritising the potential difficulties that may be presented to an individual worker? Do you accept that that's the policy logic of this bill, that it's saying we're putting the interests of children first, the workers' interests in terms of the financial impact of a fine is a secondary consideration when you're giving paramountcy to the interests of child safety?
I would agree that it could be described in that way, but I think the issue is the example I gave earlier about, in some areas, what happens under the bill is that it builds in a disincentive for reporting because of the heavy fine, because of the way the strict liability offences that are fined. So I think
But aren't the fines higher for non-reporting? Like, isn't the penalty, that the risk is actually greater if you don't report, that you're exposed to even greater hazard from not reporting as opposed to the risk that's presented by reporting?
I'm just trying to think where the risk of I don't know, I'd have to have a look at the Act. I'm not sure whether reporting is dealt with under this Act. I think it might be dealt with under other legislation, and I'd be very surprised if the fines are anything like this. So, for example, in a school, I have never heard of a person being fined for a failure to report. They may face disciplinary action, they wouldn't be fined, and they also wouldn't face a fine in the sort of circumstances, for example, children not adequately supervised. So that has not been an approach in other sectors, and I understand that it's a response to heightened community concern, which is absolutely justified, about child safety. I understand that. But it seems like I would say there needs to be much more consideration about how these operate in practice. So what are the practical implications of the changes? And it might be that the intention is that those fines would in fact not be imposed on people where an offence has occurred, because it's seen that the person is not liable, or would be unfair to impose a penalty. But it seems to me that to construct legislation which gives an independent arbiter or the regulatory authority the discretion as to whether they would go after an employee in those circumstances, that seems to me fundamentally unfair. I mean, does the New South Wales Parliament seriously think that each of these offences justifies a penalty of $34,000? And if the answer is no, it shouldn't be in the legislation. So that would be my view, notwithstanding the fact that we support child safety.
Madam
Chair.
Go ahead, Ms. Mihalik.
You okay there, Ms. Adams? Sorry. Madam Chair, just a quick question I just want to ask. I think you made a point about the working with children check notification in 24 hours, the section 174AA. What was your concern with that? And I'm assuming you're also concerned with 174AB, because if you are concerned, the suggestion you make is that OCG should notify the regulator as opposed to the approved provider?
Well, firstly, why wouldn't the OCG do it? Because it would.
Well, they might be cognizant of what they've issued to a particular staff member, but they may have. I'm just wondering if the staff member who's been issued this negative notice that notifies they're required to notify their provider. Wouldn't it be then appropriate that the provider be cognizant of their duty as well? I'm just trying to.
But the fine I think the issue is the time frame. So let's take an example where a person may have moved house, for example, or the contact details for the employee that the regulatory authority holds or the OCG holds may not be correct. So the 24 hours doesn't seem to give a lot of room for error if there is a problem in that regard.
Well, it's the educator themselves or staff member that has the main duty, right? They've got to inform their provider. So is that the concern you have rather than the provider having to inform?
It's really the time frame. So the bill says you must...
I mean, aren't they notifying via email with these sorts of decisions?
Well,
in
it
an
depends
event?
whether there's a current email. I mean, the person, the regulatory... Let's take an example where someone's been suspended. They may no longer have access to their work email.
Right.
Now, the regulatory authority may have their work email. So that person never receives a notice. It's quite common in I would say very common in circumstances where people are suspended from work, that they no longer have access to work emails. So if the email on file is that email, well then they wouldn't receive.
Well, you're presuming that Working with Children Check has just that email and not any other emails. Is that the concern? Is that where we're...
Well, the office,
the Office of
the Children's Guardian,
yes.
that is the concern. I don't know whether they maintain a register of people's emails. I mean, obviously, if the
All right. Well, it may be something that we can put to the Minister, but I would have assumed that the individual educator has already obtained a Working with Children check prior to actually being employed with that particular provider, and the independent and the email that they provide to the OCG is probably independent of the email that they may have at that particular site.
I don't know
Wouldn't
whether
you
the
assume
OCG. I don't know whether the OCG maintains email addresses for people. So they're Working with Children check, as you.
Well, they would as you initially apply for it, right? They would keep
I
that
don't know
email.
whether they do that. I mean, you apply at the motor registry. So I don't know whether when you get a Working with... I don't have one. Yeah.
I have one, and they last for 5 years. So theoretically, your contact details could change in that time. And I am part of the NESA Early Childhood Teacher Accreditation Group, and they're often telling us to remind teachers to update their details because they've got incorrect employment details, incorrect phone numbers, etc. So.
All right, well, it's something we can clarify with the government. Thanks.
Unfortunately, that does bring us to time. Thank you so much. I do appreciate just the short turnaround for you to be able to review the bill and to give us the benefit of your thoughts, and I'm really grateful for it, and for everything you do representing workers in our state. Thank you.
Thank you.
Excellent. Thank you all for your attendance and for accommodating the shortly earlier start time. If I could ask, starting on my left, for each of you to please state your name and position title and then swear either the oath or the affirmation.
Thank you. So I'm Mel McCabe. I'm the Acting Chief Operating Officer for New South Wales Department of Education. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Good morning to the committee. It's Murat Dizdar, Secretary for the New South Wales Department of Education. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Good morning, committee. My name is Christian Holtz. I'm currently performing in the role of Executive Director, Regulatory Reform in the Department of Education. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Zoe Robinson, the New South Wales Advocate for Children and Young People. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Christopher Wheeler. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Great. And would any of you like to commence with a short opening statement?
I would, Chair, if that's okay.
Please go ahead.
Can I just begin by acknowledging that we're on the beautiful homelands of the Gadigal people, and I want to pay my respects to their elders past and present. Thank you to the committee for the opportunity to engage on this important bill. The reforms in this bill respond to the findings of the independent review commissioned by the Deputy Premier and conducted by Chris Wheeler, who is sitting alongside us today. Mr. Wheeler's final report concluded that the New South Wales Regulatory Authority's performance was constrained by the national law. The New South Wales Government's position is that the national law as it stands today protects wrongdoing from transparency. Penalties are insufficient, as are the tools available to the regulator to prevent harm and safeguard children. In response, the proposed legislation before the Parliament and this committee reflects the New South Wales Government's commitment to act decisively to ensure that the safety, protection and well-being of children are at the centre of every decision that all make. The bill is responsive to removing constraints and allows the regulator to proactively address operators that either are not up to scratch or not fully committed to the provision of quality early childhood education and care. Chair, we've listened closely to the evidence through this committee and the issues raised in Parliament. I'd like to briefly address a few of these key issues up front to efficiently assist the committee. The first one I'd like to address is timeliness. There have been concerns expressed that the bill has been rushed. Certainly there has been urgency. Media reports and the work of the committee have shone a light on failures that must be addressed. Every parent, every community member, every early childhood educator, every stakeholder would agree that a solution was needed yesterday. We owe it to every child attending a service today and into the future to get this right now with no further delays. There has been a lot of related work across the nation in this space. As you might be aware, New South Wales contributed to the National Child Safety Review. At an officer level, we've provided the New South Wales perspective relating to a number of findings from Operation Tenterfield. We also provided input into the decision, regulation, impact statement consultation process alongside other states and territories. Though for all of this, and despite best of intentions, we were disappointed to see that positions we believed needed to be implemented ended up being watered down. We accept that other jurisdictions may have a different view. They operate in different circumstances. We also accept that the various parts of the sector may have a different view. They may well have different overriding motivations, but these concerns, these frustrations and the impediments in the national law have been mounting and have been prosecuted by New South Wales for some time. The second issue I want to address is thoroughness and its importance. Mr. Wheeler brings some 25 years of experience critically reviewing the efficiency and effectiveness of public service agencies, including regulators. His findings are comprehensive, and we are grateful for his ongoing involvement in shaping these reforms to deliver a more effective regulatory framework here in New South Wales. A number of changes that are featured in this bill were discussed between jurisdictions and have been agreed by education ministers and respond to the National Child Safety Review. However, we note that it is inevitable that negotiation of varying views does slow down the reform process. And while we willingly participate in the New South Wales context, This has proved an unacceptable delay. Importantly, while we believe immediate action is needed in the interests of our littlest learners, it does not preclude further action. We take the work of this committee seriously, and we've not closed the door on further reform, either as recommended as a result of your deliberations or because of further reform work within the regulator, the ongoing and evolving views of Mr. Wheeler, or the views of the prospective Commissioner for the regulator. The third issue is paramountcy, and I want to talk to its criticality as reflected in the bill. I reject any assertion that paramountcy is not too different to the current requirements of the national law. The bill makes the rights and best interests of children the paramount consideration whenever decisions are made or functions are exercised under the law. We know that in early learning in New South Wales, and irrespective of your philosophical views on it, more than 60% of services are for profit. That's just a fact. So in 60% of cases, there is a risk that the responsibilities of those running services could be reasonably interpreted as having to prioritise profit over safety. This needs to be addressed urgently. What this bill will require is that every regulatory decision, approval, sanction or enforcement action must be tested against this paramountcy standard. It displaces competing duties, including competing corporate obligations. Providers cannot excuse unsafe practices on the grounds of profitability or commercial priorities. This principle is not standalone. It informs the whole scheme. It underpins the tougher guidelines, the new enforcement tools, the transparency measures, the regulators' enhanced powers. The second last issue I want to address is transparency. There's also been conversation around the proposed transparency measures, suggesting that they do not go far enough and that the regulators' internal risk ratings should be made public. I'm absolutely all for transparency. Parents need to be able to easily know and understand what is going on in the services their children attend. I'd also say that for too long, constraints around issues such as publication transparency have prevented the regulator's actions being seen as different to others. That is not acceptable. The last issue is our internal risk ratings. We have currently considered, Chair, your views and this of the committee around some of the public-facing assessment that helpfully brings together for parents what is known about a service, all the compliance history and other matters that the bill proposes to make public. But I think that the bill is rightfully cautious about the New South Wales regulator's internal ratings, and we've heard that caution reinforced by Mr. Wheeler at the hearing earlier this week. These ratings are operational tools to inform regulatory responses. They're about risk and how best to manage and act on it. And as it stands, publishing them could be unfair to services and also misleading to families. It could also risk gaming of the system, services scurrying to paper over the cracks when they know that the regulator is likely to visit, rather than focusing on genuine improvement. There is also the real worry of services becoming overly complacent if they know they are considered low risk. Publishing that information has the potential to make children less safe, and all of us are determined to avoid that. Can I end by saying that the objectives of this bill are clear. It's about safer children, stronger standards, and faster, fairer and firmer regulation. A national framework allows for adaptation at a jurisdictional level. New South Wales needs to change its regulatory framework. This change is required now. Thank you again for the opportunity to attend, and we look forward to your questions.
Thank you. Can I check if either of the non-department people would like to make an opening statement as well? Ms.
I just
Robinson?
wanted to put on the record that, for clarity, I'm here as the advocate for children and young people, not the lead of the Office for Youth. In that capacity. Not the lead of the Office for Youth. You might have missed that, Launch.
Thank you. And Mr. Wheeler, did you have anything additional that you wanted
No.
to say at this point? No.
Thank you.
Okay, so we're going to start with the opposition.
Okay.
Go ahead.
Thanks, Chair. Thank you all for being here. Good to see you. Mr. Holtz, nice to see you at the table. You've done many in the second row, so good to be here. I just wanted to go firstly, and you would have seen, no doubt, this morning, just some of the concern from key stakeholders about not being properly consulted on the bill before it was introduced, and I appreciate some did take that on notice, but it appears that there was limited consultation, certainly prior to the introduction of the bill into Parliament. Either Mr. Disdar or Mr. Holtz, I'm happy for whoever's best placed. Could you just speak through from, I guess, the government's perspective, what you believe that consultation process looked like?
Sure, I might get Mr. Holtz to give you some more detail here, but we're part of an early childhood education advisory group at a national level, and I can tell you who is on that group.
No, I'm more specifically interested in those who meet regularly with the Minister and yourself, the ECAG group in New South Wales, some of whom gave evidence this morning. Were they briefed about what was in the bill prior to it being introduced to Parliament, I guess?
Well, Mr. Wheeler's work had a number of people that he spoke with
Yeah.
and covered, as
on
well
this
as...
bill, though, that's what I'm interested in.
And as well as the ECAG group at a national level, because a lot of these things go to things that are being agreed at a national level, and those bodies are represented at that ECAG group.
Okay, so, but Mr. Holtz, in terms of this bill, New South Wales main stakeholders,
Yes.
some who appeared before us this morning, when were they consulted on what was in
so
the
there's
bill?
probably two parts to that and the way to respond. And first is the bill comprises a number of things, both in terms of responding to the work of Mr. Wheeler, which had its own domain of consultation. It also responds to the National Child Safety Review, which also involved consultation. In relation to the actual bill itself, there was no public consultation process specifically in relation to the bill. I think in terms of the issues relating to ECAG and engagement with them, ECAG was issued an invitation for a briefing on the bill on the 10th of September. I think it was mentioned this morning, it's my understanding there were some technical issues with the invitation, and there were limited members that were able to attend. As a result of that, a further invitation was extended on the 12th of September. I attended that briefing and I briefed ECAG members on the 12th and ran them through the bill. We had a general discussion about some queries that members had, and also we committed to engaging further with ECAG members around their queries, which they were invited to submit, as well as generally undertook to work with ECAG members more broadly in terms of implementation issues going forward.
Right, but that consultation on what's in it happened after the bill was introduced.
That's
into
correct.
Parliament. Thank you. From your perspective, Ms. Robinson, was there any attempt to consult with children or young people on this particular bill?
Not that I'm aware of.
Okay, thank you. I wanted to go to some of the specifics in the bill, just noting I've only got a little bit of time. The issue around the ministerial and regulated directions, being able to sort of come in and provide, I guess, more scope and authority of that. Again, some concerns about what that would look like, how that would be applied. Again, probably to you, Mr. Holtz, if you're best placed. What, I guess, has been the catalyst for that, and will that ministerial power or direction, or indeed that from the regulator, be across the sector, individual services, or a combination of both? And will there be any opportunity for that to be either questioned? Is it through a regulatory response that if there are concerns about any of those powers or directions, that the Parliament will have any oversight over that as well?
I might get Mr. Holtz to add to this, but we covered a little bit of this at estimates as well. With the overriding paramountcy of child safety, we face probably unacceptable situations currently where in natural disasters, bushfires and floods, we put out an edict that all schools are to close in a particular geography, but we can't do that for early childhood services, for example. So, you know, that power doesn't exist. So that would be an example of where you might use that regulatory authority power, or the minister of the day might use that power. We indicated that it would be very judiciously and carefully utilised. It could be whole of sector requirement, and it could be, like in the example I gave, across a particular geography facing a particular situation. Mr. Holtz might add to it.
Can I just clarify? Are you talking at cross purposes? Are you talking about the emergency power in when there's floods and things.
No,
Are you
well, I'm
talking about
talking
the other
about
power?
more sort of the sector. There's stuff about child protection training. There's other things in there that the minister can then have that directive that is unchallenged. I think the government has said publicly. So, when will, notwithstanding the emergency services issue, when will that be used by the minister, I guess, for other purposes around child safety? And then what's the sort of check and balance around that?
Yeah, sure. I think, Mrs Mitchell, you're talking about the kinds of circumstances that were flagged in which the directions power might be used.
Yeah.
There's two directions powers that are proposed in the bill, one for the responsible minister and one also for the regulator.
Mm-hmm.
They are meant to be complementary, and I can kind of explain the two different elements to them. But they arose partly in thinking about things like responding to emergency sorts of scenarios, through to things that were being discussed within the National Forum, things that were concerning around, for instance, if an unforeseen circumstance might have occurred, how might the regulator be able to promote child protection and safety? And there were also some issues that were looked at that were responsive to Mr Wheeler's review. He talked about, for instance, the possibility of utilising conditions to effectively put some sort of responses in place. But they have some limitations. So it was out of those sorts of analyses that those direction powers arose. In relation to the ministerial power, there's two critical requirements that need to be satisfied. Firstly, the minister can only use the direction power for the safety and well-being and in relation to risks concerning children. They must, before they exercise that power, the control, if you like, on the power, is that they must form a view on reasonable grounds that the direction is necessary to prevent an unacceptable risk to the safety of a child or children. And also in the case of the minister, they can only exercise that direction power when they have consulted, received and considered any advice given by the regulatory authority.
Okay, so and will those ministerial directives be published immediately? Will there be transparency around what has been determined by the Minister of the day?
Well, it would depend on the nature of the direction. So, for instance, if it was a broad sector-wide direction, we would envisage, broad publication requirements, and that's contemplated as well. So it depends on the context.
Okay, but if say there was a specific service, because my understanding of the bill is it can go down to that granular level. If there was a particular service or provider that the minister or the regulator had concerns about, and they said our direction to you is that you need to do, X, Y, Z. It might be CCTV, it might be additional training. Will the public and the community be able to know that the minister has made a direction of that nature, and how soon will that information be publicly available?
I think it's not a specific requirement in the bill at that level or scale for it to be published. However, there would be other capacities in the bill for that to be determined. There might be, for instance, a public interest concern. So the minister may, on their own motion, decide to avail the broader public of the exercise.
But they also
of those
may not.
functions.
It's not a requirement.
Well, because also for reasons that you mentioned, it might be used in a particular, and this would be an exceptional circumstance, but for instance, in a matter of child protection or compliance type concern, there might be other countervailing reasons why it would be appropriate for those direction powers not to be made public. It would depend on the circumstances.
Can I just add, in the main, the intent would be to have that information published. We're looking for more transparency. If it related to a specific service, it's going to those parents making decisions around that service. So in the main, you'd find that the intent would be to publish.
Okay. I want to also go to the issue of, I guess, more transparency around breaches, issues with services that might be being investigated for certain things. What is going to be sort of the threshold or benchmark? There was some discussion again by the government that things would be more readily on display for parents to be able to see breaches. The bill doesn't sort of say specifically what that benchmark or threshold will be for what's reported and what's not. Can you provide any clarity around that?
Yeah. Look, and I think we've also sort of discussed that in terms of the briefing, and it's a really good question. The short answer is that the regulatory authority will provide guidance around the form in terms of how that information will be made available. Bearing in mind there's also other publication powers that the authority has insofar as the more publication that it will make on its website. But the short answer is we'll need to go through a process to work out exactly how to make sure we provide the right level of information, bearing in mind, as I say, the discussion we had, there might be a lot of breaches. We don't want to give families, 10 pages or extensive detail. We want to give them meaningful information in terms of their compliance performance and history and their commitment record, so that prospective parents or parents and guardians of children at a service can make informed decisions. But we'll go through a process. That's the kind of engagement that we'll have through, for instance, ECAG, to try and make sure that we get that balance right. What this bill does is provide the power to ensure that that level of information, once we resolve that, will be made available to parents, guardians and families in relation to those services.
Thank you. I need a little bit of time. I just want to ask about the setup of the Regulatory Authority Fund. And I know, Mr Whelan, in your report you did talk about, I think it was recommendation 12, about funding of the RA to be indexed, I guess, proportionate to the number of services. Can you explain, probably back to the department more so than you, Mr Wheeler, but did you have any input on the idea of the fund, or was it more just that there should be adequate funding for the Regulatory Authority that was the nexus of your recommendation?
My primary objective was there had to be adequate funding.
Yeah.
And that it needed to be relevant to the obligations being placed on the Regulatory Authority.
Okay, so with the idea of the fund, which is new, again, sort of the rationale from the department or the government around the establishment of that, and has any consideration been given to potentially, rather than using that money to fund the regulator, to fund it to better support uplift in the sector, which is something that some of the stakeholders have been speaking about?
So there's a couple of things, and Ms McCabe might add to this.
Mm-hmm.
We're working to help the government set up the independent regulator by the end of the year. It's our intent to transfer all the positions and budget across for that. The government has, subsequently to our last estimates hearing, announced an additional $55 million into the regulator, and that would go to some of the work Mr Wheeler undertook as well. In terms of the fund, having this sort of special deposit account fund without any sort of fines quota is not to circumvent any of the funding that already exists, or the $55 million in additionality, but the regulator may be able to tap into what that looks like with or without fines, so that it doesn't just go into general consolidated revenue and into what other priorities may look like. That's its intent. We're here at 2025. We've seen all of the evolving space. We want to lead the country in this space, but to make sure it's well funded into longevity, and that special fund can also help the regulator in that sense. That's its intent.
But the only money going into that fund will be from penalty notices, fines, infringements. Is that correct?
Well, it's got its current budget, which will go from the department to that independent regulator.
Yeah, but that's not the fund.
No, and then it's got the additional $55 million government has announced, and at estimates I indicated recently that the current budget of the regulator is about $50 million, with a workforce of about 450, 500. We can give you the exact numbers. That'll go directly across. Then there's this recent announcement by government of an additional $55 million, and then any of these fines, rather than go straight into consolidated revenue, the fund could help the regulators work into the future.
Okay, that's my time.
Ms Mahalik.
Thank you, Madam Chair. If I could just begin, probably with Mr Wheeler, just on a couple of issues. One, I did ask the previous panellist. I raised the issue that within their submission they raised concerns about the WWCC requirement that an individual that receives a negative notice from the OCG under Section 174A and 174AB, that they are then required to obviously notify their approved provider. And I think the issue that this particular union had was that the email that they might be notified by the OCG that they have received a negative notice, i.e. a disqualification or a suspension from their working check would then be sent to an email that was no longer in service or in use. I did put to them that WWCC is something they should already have prior to probably becoming an educator, and it is connected to their Service New South Wales account, and as such that would probably be more likely a private email that the individual has put forward. What I'm putting to you is what the other issue that they raised at that point was that the 24-hour notice wasn't sufficient. Can I just ask how you came to that view? That and look, I tend to think 24 hours is a good round figure, but I'm just wondering how you came to that conclusion that it should be within 24 hours notification. Or was that something the department did?
I think that was something the department did. I didn't
Mr.
specify a
might be able to
time.
respond to that then.
Yeah, as we try and work through the entire reform package of enhancing child safety, we want these reports to come in quicker so they can be acted upon. I think if you put the average test out there, I think most New South Wales citizens would think that's an appropriate time period. I can comment for the 100 public preschools I'm responsible for, which has our teachers and principals who are mandatory reporters. That has to be on the day of the incident. So we tried to strike a balance from where we're at and where we need to be, and when you're looking at enhancing child safety and putting that as paramountcy, we're of the view, and it was our recommendation, that 24 hours is a reasonable time to report an incident so that it can be looked into.
Well, I think we're in furious agreement. So I just want to clarify that. That was one of the concerns. I also want to just ask, if I may, it may be to you, Mr. Disto, or maybe
Sure.
to Mr. Wheeler. There was concerns about the penalties that was raised, and I'm sure you would have heard some of the previous panellists here this morning about having. I wanted to understand why you've chosen to penalise in certain instances both the nominated supervisor and the operator themselves. Is there a reason? What sort of led to that conclusion that it should be both?
Yeah, I might get Mr. Wheeler to add to it, and Mr. Holtz may be able to too. The first thing I want to make clear is that the nation has agreed to triple the penalties.
Yes.
The penalties are insufficient. And something that I've also picked up and learned and been briefed on, Ms. Mihalik, that might be of interest to the committee, this will bring these fines into line with, for example, the aged care and disability sectors, you know, where we've been way below what would happen in those sectors. We're not shying away from the fact that these penalties are to act as a deterrent across the sector, including for the services that I'm responsible for in public education. And they're on a not only an increase but also a graduated system, and we're looking to also apply them to a lot more areas than the national law allows for. You know, and it goes back to my earlier commentary around there's no one single thing that we're trying to pull off here. It's the package of reform to enhance child safety. If you accept the bill's intent, the nation's intent around child paramountcy, which I need no convincing of as an educator, then we respect Mr. Wheeler's review, we respect the nation's work, then you look at all the pieces as a jigsaw that can help. I mean, is it acceptable for a New South Wales citizen, as it stands, that the fines are less than a parking fine in some instances? You get more for a parking fine at the moment. So, you know, this is not my words, it's the words of Mr. Wheeler's report and the work of the nation. Child Safety Review tend to feel that it needs overhaul. That's the intent here.
Mr. Disto, sorry, just on that issue about, and I agree with what your commentary there, but your response, but just to clarify, the nominated supervisors, that was a very real concern that was raised previously. I just wanted to check if there's any response to that, why both the operator and the nominated
Yeah, I might get Mr. Wheeler, Mr. Holtz to first add to that.
I'll just jump in there quickly, Ms. Mahaley.
If there's any research or to back
So
that
I
up.
think that a lot of that discussion came in relation to the new offence around inappropriate conduct.
Yes.
That particular offence was one of the recommendations arising from the National Child Safety Review. The fines that were being talked about were in terms of the maximum, so that's if you prosecute. There are also other kinds of fines in the system, so I'll just clarify that. But specifically in terms of inappropriate conduct, the discussion at national level was, and this is the offence that relates to grooming behaviours, that everybody in the system, every relevant person in the system has a responsibility to play in terms of child protection. So that's why in relation to those things, there are functional responsibilities of each person in the system that's expected to play their part to try and ensure, we maximise child safety.
And just quickly, do I still
No, you're out. Sorry.
Okay.
But just following up on that, because in terms of, I think the drafting is just very different to in other places for nominated supervisors. So when it comes to preventing, ensuring against harm to children, a nominated supervisor's role is to take all reasonable precautions or something on those lines.
Yes.
Here it's just, they just are liable and they might not have even been there.
I think the phrasing that's used in each of the offences for the persons is that they must ensure.
Okay.
So it's a deliberative, proactive obligation for all of those.
It's not though. In the other, it's not the same as the existing provision.
No, and that formulation was reflecting the strength of the policy positioning that came out of the National Child Safety
So you
Review.
think that somebody who is a nominated supervisor who might be on holiday or whatever, $34,000 for someone who earns, $60,000, $70,000 if they're lucky, that is an appropriate fine for someone who wasn't even there?
Well, I don't like to talk in hypotheticals, but I would just say that is in the context of a prosecution, and that would be in the circumstances of quite aggravated behaviour, I would expect.
Is that a pinable offence?
That particular offence, I don't believe it is.
Okay, so that one would have to go to court.
That's my understanding.
So,
I'll check that for you.
Can I just also add, if a nominated supervisor's not there on holidays, there'd have to be a nominated supervisor at the site.
Yeah, that's not actually true. But you can come back to me on notice if you want to give me evidence for that, but that's not the evidence we've received.
If a nominated supervisor is on their holiday break, it can't be that no one's not in charge of the service.
Well,
Just like if...
I'm not, sorry, apologies Mr. Starr, I don't want to waste my time arguing the point with you. We've had the evidence. If you've got a contrary view, please provide it on notice. Yeah. If I could come to you, Mr. Wheeler, one of the really welcome bits of your review was in relation to the establishment of an independent regulator, and it really sort of fit in with some of the other reviews in that idea of having this sort of standalone regulator. I'm quite concerned that there are provisions in here that seem to actively make the regulator more within the control of government, and particularly when it comes to these ministerial directions. Do you think that sort of all sort of encompassing power where the minister can tell the regulator what the policy should be, they can give them far more than just a statement of expectations and actually override some of their decisions in effect by issuing their own direction, is a step towards an independent regulator?
There are a number of independent regulators that have very similar provisions. Or regulators are supposed to be independent.
Yes.
So,
can you tell me an example?
NRA is a National Resource Access Regulator for water.
Okay.
Has a provision. The Greyhound Racing Act has a provision. The minister can issue a direction, but it also contains limitations. The minister can't make decisions. You might be able to specify maybe a policy issue, but the discretion remains with the regulator.
In this case, though, the provision says that it specifically says that the minister can't override a decision of the regulatory authority. However, it says notwithstanding that, the minister can still issue directions to individuals. What would happen if there was an inconsistent direction from the minister and the regulator?
That is something that is a theoretical possibility. I think if the regulator issued a direction and the minister issued a different one, the regulator, I think, would be almost obliged to remove theirs. Can I just
sorry,
expand on that just slightly? It's a bit like delegations. So if you delegate a power, you can't direct how it will be exercised, but you can also exercise that power. So you've got a delegate that can exercise the power, and the position that delegated the power can also exercise it at the same time. So it's not a unique situation that you might have two people with the power who make different decisions.
Unfortunately, I don't have very much time, so I'm going to go a bit quickly, sorry. But I don't know if you're aware of the OECD best practice guidelines for independent regulators.
I have read them, yes. Indeed.
And so they have a lot to say about this kind of encroachment, I guess, on an independent, so-called independent regulators authority. But also, there's a provision in there which cautions very clearly against the establishment of an independent fund or a separate fund in which basically it's cost recovery through fines. And with the best intentions, setting up any kind of a fund where fines go in and that can then be used to put on more inspectors or whatever it is, can have these kind of unintended consequences. Did you take that into consideration?
Number one, while I agree with the idea of the fund, that wasn't something that I recommended.
No.
I'll just make that point. But number two, the idea that money from funds goes back to the organisation that levied the fine, that's all local councils. They get their money back. It doesn't go to consolidated revenue. There is another organisation, I can't remember which one it is now, which also gets the money back. This fund is going to be where the Parliament will be deciding what the budget is.
I put it to you that a local council is a level of government more similar to the state government.
Yes.
So that's fine. If the state government as a whole fines and that money goes back into general revenue, that's the equivalent of the councils. But what I'm asking you here is whether this fund and this ministerial direction power together, when you look at something like the OECD guidelines, is actually making the regulator less independent under this bill than it would be otherwise.
I can't see how the fund would do that.
Okay, the ministerial directions and
the ministerial
making
direction
policies.
Is about effectively policies. Now, a policy, you can't direct that there's a blanket implementation of a policy. It has to be a discretionary decision which cannot be dictated. You can't have for example, a delegation will say you have to act in accordance with the law and any policies of the organisation. Otherwise, the decision is the delegates. But the decision can also be made by the person who delegated that power. And you'd have a similar situation here. The minister delegates, and in other situations where a minister delegates a power, doesn't prevent the minister exercising that power.
I think we have a different idea of independence. That's all right. Mr. Diadam.
Thank you, Chair. I wanted to first perhaps go to Mr. Holst in relation to just perhaps if you could elaborate on the distinction between penalty notices and prosecutions.
Yes, thanks, Mr. Diadam, for the question. And just before I might just clarify for the Chair that the offence in relation to inappropriate conduct we were discussing is not a penable offence under the proposals. But yes, and that's kind of a new feature in this in the bill, is kind of a series of what we call, I suppose, a graduated compliance and enforcement regime. So prosecutions, and the way in which the bill is constructed and the way the national law is constructed, is it sets a maximum penalty amount for the offence. That is, in all instances, has been and continues to be under these changes, the offence that a court, the maximum offence that a court could award in the context of a prosecution. So that's the construct that the bill uses. Where PINs are available, and there were limited circumstances which have been expanded by the proposal here, PINs can be issued at 10% under the national law of the maximum penalty amount. So that's an existing construct, and that flows through, but obviously at the 3 times across the board increase. And then just to complete that out, because I think this came up as well before in relation to the disciplinary provisions, which are new in this. And again, it's part of that graduated sensibility that we're importing into the bill. Where a fine is able to be issued on a PIN basis, on a civil standard, at a disciplinary level, the disciplinary fine that could be issued in that context is 50% of that PIN amount. So I know that you've got to sort of follow it through, but obviously smaller amounts at that discipline level being 50% of the amount that would be for the penalty notice infringement.
Thank you. I wonder whether perhaps, I think Ms Matthews raised concern about this perverse incentive issue around a potential incentive for people to not report because they then expose themselves to potential prosecution. Can you perhaps talk to that element in the bill?
I'm happy to. I think one of the critical requirements that we've seen through the national discussion, through the National Child Safety Review, and certainly something that is encouraged in terms of the importance, is of proactive notification. It's something Mr Wheeler might be able to talk to, but it sits behind the strength of the recommendations that he made, for instance, in relation to whistleblowing, the importance of having that information made available, such that whether you're managing a service or whether you're the regulator, proactive information assists in dealing with something immediately, which is in essence aligned with that concept of children come first, the paramount consideration. So that's probably the policy essence. I don't know if Mr Wheeler would like to expound further on that, because it's a broader concept that underpins, I think, many of his recommendations.
Mr Wheeler?
I think there's already a situation in the legislation where if you report something, you might be held accountable for it. But then you'd have to consider, the circumstances of the individual case as to whether any action would be taken at all. If somebody reports something very quickly and they've taken appropriate action to try and address that problem, that has an impact on a regulator's view about what steps they need to take. Now, if it was absolute negligence on the part of the individual, chances are they're not going to report it in the first place. I mean, let's be realistic about it. Somebody else will report that. And a lot of what I was thinking about in writing the report was how can you try to ensure that other people will report conduct which is inappropriate. And so it meant that you need to have protections for all the potential people who might be aware of a problem. And so it can't just be, which is the current situation, that it is current employees. It needs to be current employees, former employees, parents, any person, which is what the current provisions of the bill cover. Any person can make a disclosure of serious conduct to the regulator. You could also make it to the management, but I would think, if somebody was concerned about their position, they would probably go to the regulator first.
Thank you. We had some earlier evidence around concerns about the possible circumstances of ambiguity on inappropriate conduct. I wonder, perhaps Mr. Holst, you're the best person to respond to that evidence.
Yes, thanks, Mr. Diadam. And look, I guess what I can say is that it's an important, the context here is important in terms of where the idea and the policy behind this offence came from. And I think I mentioned before, it came from the National Child Safety Review, which was reflecting on the lessons learned in light of Operation Tenterfield and the gravest crimes that occurred in Queensland, New South Wales, and I think also Italy in relation to that particular individual. And I think there was a reflection, generally speaking, that there was a gap. We have an offence that relates to inappropriate discipline, and I think that's generally well understood within the context of the sector and also within regulators. But there were these sort of more contextual matters that were alarming, and that's what caused policymakers to have this conversation and ultimately reflected in the offence that's now known as inappropriate conduct in the bill. It deals with, in simple terms, what might be described as perhaps grooming behaviours, and I think it really depends on, it is a difficult offence to define, and that's because it is contextual. It relates to age of the child, it relates to context, and also the conduct. So it's really important that it's assessed in the context of the circumstance. But what it does, what I kind of probably would like to just clarify is some examples that were discussed nationally were things like sexualised comments and jokes, over familiar physical contact, secrecy with a child, don't tell type requests, one-to-one unsupervised time without justification, gifts, favours, favouritism that create dependency, retaliation or intimidation when concerns are raised. So these things, do need to be examined in context. It's also one of the reasons why another part of what is going to occur nationally, and this is being developed as we speak, will be training in this regard to ensure that everybody in the system has a better capacity to be able to identify those kinds of things, certainly be encouraged to report them, but certainly be much better aware and able to kind of be responsive to those things. But it is a gap in the current regulatory regime.
And I just want to add, Mr. Diadam, the regulator will be responsible for giving a plain English communication to the sector, fact sheets, FAQs around what Mr. Holt's described, explaining this new offence, how it's applied. We're not going to publish a loophole creating checklist, but he gave fantastic examples, sexualised comments, secrecy with a child, one-to-one unsupervised time, gifts, favours, favouritism, retaliation or intimidation. These things are examples that will provide the sector of where this would come into play, but not an exhaustive capture-all list. If it's criminal, I know you'll appreciate this, if the offence is criminal, we'll be referring straight across to the New South Wales Police.
Thank you. There was earlier some conjecture about who is liable where a supervisor is on leave. I wonder if someone might be able to provide some clarification on that.
Yeah, let me take up that opportunity, Mr. Diadam, and for the chair of the committee. Folk have provided me with advice. Every service, the 6,500 out there, has to have a delegated responsible person on site at all times. And it's an offence to operate an education and care service unless there's a responsible person present. But the approved provider and the nominated supervisor, maintain accountability at all times, even if they're on holiday.
Okay, thank you. And I might just take this opportunity to see if there are any other areas of evidence taken today that any of the panel would like to respond to.
I don't necessarily want to respond to the evidence that was today, but I do think that whilst everyone has talked about the intentions of all of this and where it comes from, the people who will be ultimately impacted by every change is the littlest people who are in these centres. And I think there is still some work that needs to be done about, I know that people might say you can't sit with them and ask them questions, but they should be voices in this, and they will be impacted it. They will see cameras in their centre, they will see people's behaviour change, they will have different kinds of relationships, and it might also see some of our really beautiful community preschools in a situation where they can't exist in the same way that they have existed. And so I do think I'm thrilled to see the best interests of children are there front and centre, and I'm glad it's being spoken about in so many places. but we're still doing it in the absence of the little ones in the room, and I still think that there's room for their voice to be part of this.
And I just want to add, as Secretary of the Department who will help government set up the independent regulator, we remain committed to work with the advocate on the implementation. I know the committee would appreciate that 30% of services without the legislation already have CCTV without the national trial. So I agree with the advocate that we're looking for child safety as paramountcy, and we're looking to raise the bar. We'll work with the advocate, who does a great job in capturing from littlest to growing voices around implementation of the intended legislation.
Thank you. I think that's all the questions that the government have, and I think we're pretty close to time.
We are. I'm just going to ask a cheeky one.
Oh, you ask. No, you go.
I think we've got the same one. Go
yeah,
on.
no, you go.
Just
We
a
might
cheeky
not,
one.
just in case.
Is the government the approved provider when it comes to government preschools? And if so, like, are you a large provider? And who would then be personally liable for the $500,000 fine?
Yes, we would be under the same expectation when we've got 100 public preschools, it'll become 200, that the same rules apply. I'm proud to say we've got strong operations in public preschools.
But who are you the approved provider, Mr. Disdar? Who is it for the
It's the
government preschools?
Executive Director for Early Childhood.
Right. So if there's if there's an issue in one of these services that's government run and that's liable for a $500,000 offence, does that fall to that individual? Who
It'll
pays
fall
for it?
to the department in the first instance.
Right.
If there's any criminality.
Yeah, of course.
Of course, it'll be the.
But not an individual.
It'll be the teacher or the principal or the, depending on the circumstance.
Okay.
But if you're talking about financial penalties, it can apply to the organisation, but individuals are not cut out of that either. It could, depending on the instance, apply to the individual as well.
Yeah, or the nominated supervisor at a particular service
Correct.
in the same way.
Correct.
Because under the bill, the large providers, each member who's sort of on the board or whatever, so presumably is personally liable. So then
Yeah.
presumably that would cover Mr. Barricade as that's an interesting little.
We would continue to work hard like we have been to support our services and maintain the high standards.
Well, we know that the government services are statistically far safer than the private ones. Okay, sorry, I'll clarify that, the large for-profit ones. All right, that does bring us to the end of our session with you. Thank you very much and for accommodating the early time. To the extent there were questions taken on notice or supplementary questions, I understand there's a truncated time frame for that, but the Committee Secretariat will be in touch. That does conclude our hearing for today. Thank you very much.
Thank you.